For withdrawal of a review application.
Yes. Mention extension of it. Yes.
Withdrawal of a review application.
Yes, yes. It will appear to mention.
This is actually this order was passed by subsequent certificates. But withdrawal I had
with Justice Kumar or Justice?
This is but we are withdrawing it as non-prosecution, right? You don't think there's it was not even admitted, just fine.
Mention only the extension matters. We're not adding any further matters this week. Next week we'll add again. Application, please mention.
My junior mentioned
only extension of interim order is mentioned.
My junior had mentioned in last Monday, by the impugned order, the entire committee has been made defect. The committee cannot function.
We understand, sir.
So I'm sorry.
Next matters
next Monday. Maybe
add matters next week. Mike ta din.
I'm sorry, but
Mike ta kache din. Kono mic nahi kiya. Please mention, call the column. Only extension of interim orders, please mention this. No.
Contempt application.
Yes, column.
Order for restoration by tomorrow.
Accordingly, FMA number 1360 of 2025 is allowed on contest. They were setting aside the impugned judgment dated July 3, 2025, passed in WCA such and such, as well as the decision of the respondents to reject the renewal application of the appellant by the order dated May 7, 2025. The respondent number 2 is hereby directed to consider the renewal application of the appellant afresh and to grant renewal within the ambit of the renewal clause in the appellant's lease deed dated May 2, 2019, subject to the condition that the appellant has performed satisfactorily under the lease deed. Such processes shall be concluded in the light of the above observations as expeditiously as possible, positively within 2 months from date. There will be no orders of cost. Consequently, can is also disposed of urgency.
Number 2.
For the appellant way.
Where is the appellant?
Matter was disturbed.
So mediation has failed.
Mediation failed also.
Since the mediation between the parties has failed, as is evident from the order of the mediator dated August 4, 2024, let the appeal be listed for hearing in the next month. The appeal will again next month.
Any date can be placed.
Item number 3.
None appears for the parties at the time of call. To stop. Let the matter stand adjourned for the day.
Item number 4.
English note same.
Item number 5.
আগে কোন অর্ডার থাকলে দেখাবেন সেম
Item number 6.
সেম
Item number 7.
সেম অর্ডার
Item number 8.
সেম
9.
সেম
Item number 10.
সেম অর্ডার
11.
সেম অর্ডার
12.
সেম
13.
সেম
14.
সেম
15.
সেম অর্ডার
16.
সেম
17.
সেম
18.
সেম অর্ডার
19.
সেম অর্ডার
20.
সেম
21.
সেম
22.
সেম
23.
that matter. Was proceedings.
Yes, yes.
And I think it was making some submission.
Yes, yes.
But there were initial attempts to do that.
Yes, unless they finish the process.
After the thing. We have prepared our notes.
Right, let them finish first, because if they add something, you may have to add. Although the appellant is represented by counsel, none appears for the respondents. Full stop. The matter is heard in part, and was due to be heard on the arguments of the SSC. Full stop. However, since none appears for the SSC today at the time of call, you're appearing for the SSC. Make your submissions. You're ready in the matter, SSC?
I'm not ready.
Comma.
Facilities.
Let the matter stand adjourned for the day. Next.
Item number 25 and 26.
None appears for the appellants at the time of call, although the respondents are represented through counsel. To serve, let the matter stand adjourned for the day. Adjourned for the day means whenever the old matter is called.
Item number 27.
You're for the respondent. None appears for the appellant at the time of call, appellants at the time of call, although the respondent number 3 is represented to counsel. To serve, let the matter stand adjourned till the adjourned and be listed in the next monthly list.
27 euros.
27, you're ready?
Lordship,
I made it next monthly list. Next.
Item number 28.
28 minutes.
Yes, please talk about it. Anybody is appealing for the other side? At the previous stage, no.
No, only one problem while I'm facing while going through, if a document in respect to an advocate commissioner report is required. I have tried to get him, it's an old matter, but they just.
What is the matter about?
This is a for eviction. Licensing was given for a month.
You are the
Well, I am the defendant before your lordship.
eviction of licensee, yes. Both courts will yes. What is your ground?
But my ground is that, my lord, they have made out a case that they have given a license for a month in court. Now, during the pendency of that 1 month license, they have revoked it and filed this suit. I have come with the defense that I was in possession since last 15 years, but I have constructed a house. Plantation was there, everything is there, and big cuckoo was also taken care of. After that, this court has not considered the commissioner's report. And that is probably one of the best evidence.
How is the commissioner's report relevant?
But the commissioner was given
the license, your status is a license.
Even they have contradicted their own case. PwC has come to the.
What was your case? What is your status?
My case is that 15,000 I have given in 1880, in somewhere 15 years ago.
Have you produced any agreement with me for either?
No, I have not produced any. No, but I have other case. That I was in possession, I have also claimed this to adverse possession.
Adverse possession?
But I have constructed a house, that will be evident.
Purely on facts, actual question will be more.
Well, Lordship will kindly see the trial goes in.
Yes.
Like trial goes judgment, the Lordship takes from internal page to the plain case.
plain case where
if I मतलब
it's your onus, the defendant's
Yes.
onus to show your status.
only I was required to read before your lordship मतलब
What evidence did you give on adverse question?
that is the advocate's report, commissioner's report. That is
Commissioner's report cannot show adverse question from
No,
the relevant
madam,
content. Commissioner's report cannot show anything, only structures and
Madam,
reports.
I
Position
think
is
that
that-
the plaintiff case, plaintiff has demolished his own case by his evidence.
Plaintiff need not make out a case. Plaintiff has to say that you are in possession and he wants eviction and allege that you are a licensee.
Madam,
It's your owner's burden shifts on you.
he says that I am in possession for only 15 to 18 days. On the contrary, madam, his evidence he has shown that somebody is saying I am still last 3 years and madam, if you lost
Immediately.
only problem
Unless you
is that
show any status, legal status of your possession.
yes. No, what you will kindly see, madam. Internal creation effect philosophy allows you to be.
Yes, yes, absolutely.
From second paragraph only I am reading.
Yes.
নালিশি সম্পত্তিতে বিবাদী কোনো শর্ত নাই পূর্বে নালিশি সম্পত্তি তাদের কোনো দখল ছিল না 1 নম্বর বিবাদী 2 নম্বর বিবাদীর সাহায্যে নালিশি সম্পত্তি গায়ের জোরে দখল করে নিতে গেলে বাদীনি তার বিরুদ্ধে ফৌজদারি মামলার আইনের 144 ধারায় দরখাস্ত আইন করে দরখাস্ত বাদীনি কিছু ভুল থাকায় পরবর্তীকালে বিবাদীগণ উপায় না দেখিয়া বর্তমান 1405 সালে 6 পৌষ থেকে কেবলমাত্র পৌষ মাসের বাকি দিনগুলিতে নালিশি সম্পত্তিতে ভোগ দখল করার জন্য বাদীনির কাছে অনুমতি দান এবং তখন বাদীনি বাধ্য হয়ে বিবাদীনিকে ওই পৌষ মাসের বাকি কটা দিন থাকার জন্য অনুমতি দেন এখন বিবাদীগণ পরস্পর যোগ সাজসে নালিশি সম্পত্তিতে তাদের নাম বর্গা রেকর্ড করিবার জন্য পুনরায় উদ্যোগ নিয়েছেন জানিয়া বাদীনি পৌষ মাসের শেষ পর্যন্ত অপেক্ষা না করে 25শে পৌষ 1405 সালে অনুমতি প্রত্যাহার করে নেন এবং বিবাদীগণ নালিশি সম্পত্তির খাস দখল বাদী অনুকূল ফেরত দেওয়ার অনুরোধ করে বিবাদীগণ বাদীনির অনুমতি প্রত্যাহারের অনুরোধে অগ্রাহ্য করায় বাদীনি বর্তমানে মামলায় প্রণয়ন করে নালিশি সম্পত্তি বিবাদী কোনো প্রকার সত্য না বৈধ দখল নেই প্রচারে আর্জি প্রার্থনা অনুযায়ী প্রতিকার প্রার্থনা করেছে বিবাদীগণের বর্তমান মামলায় হাজির হয়ে প্রতিদ্বন্দ্বিতা করেছেন এবং লিখিত বর্ণনাপত্র দাখিল করেছেন পরবর্তীকালে বর্ণনাপত্র সংশোধনী দরখাস্ত দাখিল করা এবং সেটি মঞ্জুর হওয়া বর্ণনাপত্র কিছু সংশোধন করে বাদীর সমস্ত বক্তব্য অস্বীকার করেছেন এবং বলেন যে বাদীর মামলাটি আইনত সিদ্ধ নয় এবং স্পেসিফিক্যালি 34 ধারার মধ্যে বাড়িতে এবং নালিশি সম্পত্তিতে বেগ এবং কাল্পনিক এছাড়া বাদীর মামলাটি দামাদি আইনে বাড়ি বিবাদীগণের প্রকৃত কর্তৃত্ব এই যে বিবাদীগণ গত 15 বছর বেশি সময় আগে বাদীকে প্রত্যেক বিবাদী 15,000 টাকা করে মোট 30,000 টাকা প্রদান করে গ্রাম্য লোকজনের উপস্থিতি এবং কথা থাকে যে সে সময় সুযোগ মত
Whatever you have made out a twofold case that
Yes.
they agreed to sell the property to you. One, you failed to prove any document regarding that, and regarding adverse question also, trial court finding is
Yes.
you have failed to prove that by any document that you are
I'll
poison
go
over.
back to weakness. Not should see only one.
It's an appreciation of evidence, Mr. Shukla.
I am not going to secondary lordship. Only I am placing before lordship. When the advocate commissioner's report was admitted, without any objection. Well, I was only just that there were construction.
Maybe construction,
No.
but it's still a licensing. Unless you show an agreement that they agreed with you that in view of the construction you get an indivisible right. You have nothing. There may be construction.
My case is that even one of
The licensing may make construction, but that does not entitle you to become a tenant or something else.
I am saying that in respect to that land, already 15 years I am in possession.
There is someone else's land, Mr. Chakravarti, you have built a construction there, that's subject to, he will get it back when he.
Whether the suit is within the limitation period or not. That is also a
No.
question, because he is the advocate.
License anytime.
But the license he has made out a case for 19 days.
Unless you prove any status with regard to the property, you remain a licensee. You know the usual judgment, the regular judgments that there are 3 categories of possession, either owner or tenant or licensee. If you fail to prove first 2, then you are licensed. Mr. Chakravarti, you know the fate of it.
Subject but I am ready to only 2 points to lordship kindly consider. Whether I have made a substantial construction in that land and within the knowledge of the owner, for last 14 to 15 years, that evidence and total the plain case is only based that 15 years I have given a license, you are not going, so I want a eviction. But I want that point.
Even if he fails to prove the
But even his
tenure
plain
of possession.
And now plaintiff has come before your lordship. My lordship kindly sees plaintiff has added the evidence that I don't know from where from which how much time he is deciding, more than 3 years. So that is the evidence of plaintiff. And if your lordship sees the plain manner, then the plain condition is very. Your lordship sees it manner.
Wait, whatever, if they have to seek eviction only, Mr. Chakravarti. Allege you are a licensee, seek eviction.
But a license is still there, they have created. It is not my defense is that I am.
They only have to say that you are a licensee and they seek eviction. You have to show that you have some status in respect of
But my status I am showing that I have substantial construction having been for last 15 years.
that doesn't indicate.
But whether his food is maintainable in either.
Why not?
A limitation. Only limitation.
Will deal.
Well, if you're possible, I last time, last if you 1 week's time, I try to get hold of that document. Because for last 40 years, these persons are there.
We are telling you that this inspection report does not have any meaning.
So that plain case is based on because he has filed a suit on basis of a vacant land.
We record it.
A vacant land.
The present second appeal has been preferred against the judgment of affirmance by the defendant in a suit for eviction of licensee. Mr. Learned Counsel for the appellant submits that despite a case being made out in the plaint that a license was given only for a month, comma, prior to expiry of which the suit was filed, comma, the defendant stroke appellant, comma, by way of a local inspection, comma, brought before the court evidence that there is a substantial construction made on the property by the defendants stroke appellants. So next para, as such, comma, it is contended that the plaint case failed. So next parallel, counsel argues that a plaintiff has to succeed or fail on his own case. And as such, comma, since the plaint allegation of license for a limited period was belied by the commissioner's report, comma, the suit ought to have been dismissed. So next para, secondly, comma, it is argued that even the plaintiff's witnesses failed to establish as to how long the defendants stroke appellants are in possession of the property. So thus, comma, the plaint case was demolished by the plaintiff's witnesses. So next para, thirdly, comma, it is argued that the defendants stroke appellants pleaded adverse possession in respect of the suit property. First up, the learned courts below, comma, it is argued, comma, failed to advert to the evidence in that regard. First up, next para, learned counsel submits that the commissioner report would acquire relevance in the context. So next para, however, comma, upon hearing learned counsel for the appellants and perusing the judgments and degrees of both the courts below, comma, we do not find any substantial question of law involved. So next para, the learned trial judge considered the evidence of both the parties at length. First up, it was recorded by the learned trial judge that although the defendants made out a case that the plaintiff had agreed to sell the suit property in favor of the defendants in exchange of rupees 30,000, comma, no document whatsoever has been was produced by the defendants in support of such case. Also, comma, the learned trial judge observed, comma, upon adverting to the evidence adduced by the parties, that the factum of continuous, uninterrupted, and hostile possession over a period of 12 years in respect of the property could not be established by the defendants stroke appellants. First up, next para. The contention of the defendants appellants to the extent that mere raising a construction on the property by the defendants entitled confers an indefeasible right on the defendants cannot be accepted in the absence of any specific case being made out and or agreement being produced before the trial court or the first appellate court in that regard. So next para, merely by construction on a licensed property by the licensee, comma, the latter does not acquire any indefeasible right within the contemplation of law as prevalent in India. Next para, in fact, comma, by pleading that the the plaintiff had agreed to execute a sale deed in favor of the defendants in respect of the property, in an indirect manner, permissive occupation has been admitted. Full stop. Next para, the same case is mutually contradictory with the defense case of adverse possession. Full stop. Next para, the learned first appellate court affirmed such findings of the trial court. Full stop. Next para, thus, apart from no arguable case having been made out in the second appeal, the issues argued merely fall within the domain of appreciation of evidence on facts and does not give rise to any question of law, let alone any substantial question of law. Accordingly, we do not find any merit in the present second appeal. Accordingly, SAT 486 of 2018 is dismissed under Order 4111 of the Code of Civil Procedure. Next para. No, that's. No. Discussion is finished.
Item number 29.
Yes, Mr. Ghosh, what is the matter?
Sir, I have the calculator minute.
Please move your matter. You are for the caveat? No. Yes.
But in this matter, this is a super specific performance.
Right.
But the promoter has filed the deed and the owner of the land. But after making some part of the construction is now not being carried out, and the power of attorney has been revoked by my client.
Was it a registered part of it?
Yes. Now, it is a super specific performance in which the learned court below has granted an order of injunction over further construction.
There is an agreement. They have produced an agreement.
Yes, there was a development agreement, and now after the written objection to the Order 39 Rule 1 and 2 application was filed by my client, the injunction petition application was being heard. And in the impugned order, the Lordship will find that the learned court below has totally overlooked my written objection.
What could be looked into? How could it make a difference?
My lord, the observation of the learned court below is that I have not filed my written objection at all. It goes untraversed. The application for injunction goes untraversed.
What is that finding?
My lord,
We are at the impugned order.
by previous eviction is and it again, my lord. Yes, not.
Yes, it is pertinent to mention that the contesting defendants have not filed any affidavit in opposition, challenging the dispute, not in a position to disbelieve, supposed to have admitted the case of the plaintiff.
My lord, I have annexed the order sheet, which is a date prior to the order being impugned order being passed.
Which page of your application?
My lord, it is probably page
Near the end.
at the end. But in that order sheet, your lordship will find that I have filed my written objection to the injunction application. Just prior to the impugned order.
111.
Yes. So that is your first ground, that is objection.
Yes.
What did you take? What points did you raise in the objection?
But if at all the promoter succeeds in the suit, he can be compensated in terms of money.
So damages is an alternative release, they have to specify.
Yes, yes.
Acha, one other thing, your
And moreover, my lord, the sanction plan has already lapsed in the year 2021. So even if he succeeds, he cannot make any further construction pursuant to the development agreement. So why should my property be injuncted from making further construction? If I get hold of another promoter and if I construct over my own property, how can I be injuncted?
and was there any status quo prevalent during pendency of this? Ad interim injunction was there?
No,
Very good. Let us hear Mr. Pal. Yes, Mr. Pal, what is it?
no.
First of all, court holds that there is no written objection. We have to set aside and remand and direct.
Why, my lord, may I say so?
Yes.
My learned friend has shown that he has filed. But when has he filed, he has not indicated that. Kindly sees that same order as an 111. Today is fixed for passing order. And on that day, the PO was on leave. The hearing concluded.
So 111 is
Yes,
fair
today is fixed for order. Respondent files Sajira. I'm sorry, defendant files Sajira, defendant files W. Supported with affidavit, PO is on leave to 1/2/2023 for order. The hearing was concluded before that.
Hearing was on.
Yes.
Where from?
Huh? It will appear from the order itself. Because if the next date, 1st February 2023, which is the order impugned, my lord will see, my lord will find that the record is taken up for passing order and today's date is fixed for passing order. It has been heard out previously. They have not filed written objection.
Where do you get the date of filing of the written objection?
Page 111.
111.
It's a 20 December 22 order.
111 there is no order.
In my
Order per change.
Yes, please, 100.
Okay, phone. There is only one application.
just prior to the original order, very
Outside, so in my copy it's 112. Anyway.
20 December
Fixed for final
2020.
order.
Today is fixed for order. Defendant files Sajira, defendant files W supported with affidavit. PO is on leave to 1st February 2023, and after the 1st February 2023 is the order impugned wherever when the court has passed the order. It was heard before.
But since they filed an written objection before passing of the order, it should have been looked into. We understand what you are saying, that it was already fixed for passing order just because the PO was on leave. But since they have filed an application, if on that date the order was passed on 20th, we could have understood. But when the PO came back, it was already on record.
The hearing was concluded prior there,
Might have been.
and they have not made they have not made any submissions in support of the written objection. After the hearing concluded, my lord, kindly considers, my lord, suit for specific performance of contract. My learned friend has pointed out that it has expired in 2021. But my learned friend makes that in 2019, when he revoked, he entered into fresh development agreement with somebody else. I do not have any other choice for that. 80% constructions have been done. G plus 5 buildings. But suddenly, my lord, revoked, and my lord entered into a fresh agreement. I have filed the suit, my
What
lord.
about your sanction plan having lapsed?
But that has been made, my lord, in terms of the sanction plan. My lord,
Well, the development, if your lordship looks into, my lord, the
80% construction done on the, my lord, suddenly, my lord, my lord, power of attorney got revoked. They entered into a fresh development agreement, and that's part of the record, my
But
lord.
Mr. Pal, since an objection has been filed, that had to be.
I understand, but my lord,
We'll dispose of the appeal. We'll grant status quo in the meantime and we'll direct the injunction to be reheard and decided with upon consideration of your written objection within a limited period. Whether it should be status quo for all practical purposes, final or it was already fixed or final. We appreciate that contingency.
my lord, evidence is also going. Evidence is going on. It won't take much time, my lord, to be
Do you
the
know?
truth. Instead of that, my lord may kindly, my lord, passes direction for expeditious disposal of the suit within time bound manner. I do not have any
No,
objection.
we'll first the injunction has to be heard of.
Very good. Well, this will delay the suit again, my lord.
understood, but nothing doing without the written objection, looking into the written objection. If this was done by sparing one line for the written objection, we could have acted it. You are suffering for the fault of the court, but you can't help it. The present appeal has been preferred against an order whereby an injunction application passed by the uh, plaintiff stroke respondents in a suit for specific
Number one.
performance. Pardon?
That's for number one. Right?
Acha. Plaintiff stroke respondent, both the response were not plaintiffs.
No, the second respondent is the new person who has come into the
Acha,
picture.
the filed by the plaintiff stroke respondent number 1 was allowed, thereby directing both parties to maintain status quo with regard to nature, character, and creation of third-party interest in respect of the suit property till disposal of the suit. To the next parallel, counsel for the appellant argues that counsel for the defendant appellant stroke developer argues that defendant appellant stroke owner argues that despite a written objection having filed by the defendant stroke appellant prior to the disposal of the injunction application, the same was not considered and the learned trial judge proceeded to decide the injunction application on the premise that no written objection had been filed by the defendant stroke appellant, by virtually adopting the principle of non-traverse. So, next para, learned counsel further argues that in view of the construction work being stalled by the developer stroke defendant stroke respondent number 1, the power of attorney granted by the appellant in favor of the plaintiff stroke respondent number 1 was revoked. Next para, moreover, the sanction plan obtained by the plaintiff stroke respondent number 1, it is alleged, has lapsed in the meantime. Next para, learned counsel appearing for the plaintiff stroke respondent 1 argues, by placing reliance on the order dated December 20, 2022, a copy of the certified copy of which has been annexed to the connected stay application, that the said date was already fixed for passing of final orders by the learned presiding judge of the trial court when the written objection was filed. Since hearing had already been concluded, the mere formality of passing of an order was left, and as such, the learned trial judge rightly did not take into consideration the written objection. Next para, secondly, it is disputed that the sanction plan has lapsed. Learned counsel for the respondent 1 submits that due to the defendant stroke appellant having cancelled, revoked the power of attorney granted to the developer stroke respondent number 1 and entered into a fresh development agreement with the third party, the plaintiff was compelled to file the present suit. In any event, it is argued that a prima facie case for grant of injunction has been made out. The next para, upon a perusal of the order dated December, since questions of both fact and law are involved, we admit the appeal and take it up for final disposal, in view of the ambit of adjudication being taught. Next para, on a perusal of the order dated December 20, 2022, it appears that the defendant stroke appellant had indeed filed a written objection to the injunction application on the said date. Next para, although the hearing of the injunction application had already been concluded by then, which is evident from the recording in the order dated December 20, 2022, that the injunction application was fixed for passing final order, fact remains that when the regular presiding officer returned and passed the impugned order disposing of the injunction application on February 1, 2023, the written objection was already on record. Next para says about a month and a half had passed between the filing of the written objection and the passing of the final order of injunction, the ends of justice demanded that the learned trial judge took into consideration such written objection before disposing of the injunction application. Full stop. Next para. However, comma, otherwise, comma, the arguments made by the appellant give rise to triable issues, and as such, comma, we are of the opinion that the matter should be remanded to the learned trial judge for taking into consideration the written objection, semicolon. However, comma, in the meantime, comma, the parties ought to be restrained by an order of status quo in tune with the order passed, which is under challenge before us. To next para. Accordingly, comma, FMT 96 of 2023 is partially allowed, comma, thereby setting aside the impugned order dated February 1, 2023 and remanding the matter to the learned trial judge. Then, setting aside the order dated February 1, 2023, passed by the learned civil judge, senior division, second court at Howrah in title suit number 383 of 2019 and remanding the injunction application to the trial court for a fresh consideration of the injunction application as well as the written objection filed by the defendant appellant to the injunction application. First up, the learned trial judge shall give an opportunity of hearing to both parties and dispose of the injunction application as expeditiously as possible, comma, positively within 4 weeks from the date of communication of this order to the learned trial judge. So next para, it is made clear that we have not entered into the merits of the injunction application and it will be open to the learned trial judge to independently decide the same without being prejudiced in any manner by any of the observations made herein or in the order impugned before us. So next para, since learned counsel for the plaintiff respondent number 1 submits that the suit is already on the parental board, comma, we expect the timeline given by us for disposal of the injunction application to be adhered to strictly. Full stop. Upon disposal of the injunction application, comma, the learned trial judge shall proceed with the hearing of the suit and make all efforts to dispose of the same as well at the earliest. Full stop. Next para. In view of a prima facie case having been made out, insofar as the ad interim stage is concerned, comma, we direct the parties to maintain status quo with regard to nature, character, and creation of third-party interest in respect of the suit property or any part thereof till disposal of the temporary injunction application by the learned trial. No address to court. Can 1 of 2023 is also disposed of consequential no address to court participation. প্রথমেই একটা করে দেব রিসিপ্ট অফ সার্ভিস অফ নোটিস ফাইল ফিডেভি ক্যাপ্টন
Item number 30.
এটা yes sir
Judgment of development.
very well
The defendant is rushing the suit for eviction of a tenant under the premises. Trial court dismiss the suit.
on what ground?
Trial court dismiss the suit on the ground there is no relationship.
No, it was only on the ground of prisoner record suit
We don't need suit was defeated on the ground of
other ground of
We don't need the suit was defeated on the ground of all the other grounds were taken.
trial court dismissed
Trial court dismissed.
appeal court reversed and granted decree only on the ground of prisoner record. What is the point?
No, the trial court is because our case is that we are not the tenant. We have been granted possession on the basis of intended transfer of the property a person to which a document was executed with 30,000 consideration amount. We have muted our name with the concerned local authorities and we are residing there. Not only that, we have made construction. It is in the year 1993. From the evidence of PW2, it will appear our induction and our possession since 1993 when this document was used. Now, madam,
Document you have produced.
yes, it was considered that your
that
trial court
agreement was unregistered.
understanding. Now, even so, tenancy is claiming eviction under the rental
If you
regulation.
file any specific purpose suit,
No, possession was there, and
if you indefinitely hold on the strength of an agreement, then you become a license, if not a tenant.
yes, but it is licensed and not a tenant. Madam, can consider the apex judgment. Forward to your question.
The apex court then, at the appeal court then.
Appeal court judgment. Internal page 12.
Yeah.
The moot question before this court.
Internal page, yes.
Internal page 9. Paragraph 20.
Yes, correct. Good question.
The moot question before this court is to decide what is the status of defendant in the suit property. Is he a tenant under the plaintiff or does he have any right in law? This nobody's case the plaintiff has granted in license in favor of the defendant. There is no scope to adjudicate this point that the defendant is the licensee in the suit property. All the points raised by the defendant have no basis. The plaintiff has contended that the defendant is a tenant under him as the verbal understanding between them and the rate of rent was 500. Payable according to image calendar number. Defendant did not a lawful buyer. He is not adverse possession. He is not a licensee in the suit property. Then he has no other status but a tenant. So this is the
Reasoning is wrong, but the
consider if it is a suit under the special renewal legislation. The suit was being I have told you that if a suit filed under the renewal legislation, then on the basis of title it is under the transfer property. He initiated the suit, it is not a suit.
Mr. Rai, if the suit was filed on the premise that you are premises tenant, now the Premises Tenancy Act empowers a civil court to decide. It's not a person or designate.
Now,
So therefore, that court had the power to grant a decree of eviction even if he was
they might not be amended. It requires to be amended.
no, the court can find from the materials on record.
That
In
is
this case, has not-
that is why the court proceeded manner. So even if
That's what we
I
are saying. The reasoning is wrong at the conclusion.
even licensing, I'll produce the I'll show you
If there is an agreement, you go by your best case. You have an agreement. Unregistered or not registered, we are not going to that. But
possession transfer.
possession transfer in 1993. You have never filed any suit for specific performance of agreement. Now, even after at least after the eviction suit was filed, a cause of action arose because obviously they denied that agreement, even if there was an agreement. Now, therefore,
the injunction was 2000,
Yes.
according to the plaintiff.
when was the suit filed? Sir,
2012.
2012. So, therefore, after at least 2015, after passing of 3 years of from 2012, your right of filing a specific performance suit has gone. Therefore, your status is nothing in respect to this program.
That is what precisely what I have submitted to the lordship. It is his case. It is his case that I am a claimant in the
Failed to prove.
failed to prove.
Failed
Then
to
what is the status of my as a state person?
You-
What is licensing?
Yes.
If it is licensing by law, though is
Either trespasser or license.
then if it is licensing by law, the construction has been done and made on the basis of license. Then though Inspector Act does not apply. I suspect also the PW2 himself stated that yes, I have made the construction.
Judgment Act confers indivisible right.
Yes, but
That is not available in West Bengal.
but the principle is applied and I am entitled to get.
Indivisible is applied only the basic principles regarding easement and all. But indivisible right is a right conferred by the state.
That I am not paying. This was
Whatever you have made construction, he gets it with the construction. Whatever developments you make to land.
I am entitled to get compensation. If that be so.
Have you filed a suit for compensation?
No, that was because I am entitled.
That does not save you from or for a defense in the eviction.
So without amendment, there are no without
Without
amendment.
amendment, yes. Court finds from the materials on record he failed to prove his tenancy case. But even then, what is your status that has to be considered? Suit is at the end of the day for eviction of your eviction. Even if a lesser status is established from the materials on record, then it goes.
But the reconciliation suit can be converted into regular suit.
That judgment side. That is the best case.
Yes, it was 2014 volume support is a 788.
But the language of Premises Tenancy Act is now civil code, probably.
Yes, civil code, still civil code. 97 initially it was controller, but not civil code.
Relevant paragraph is
Yeah. 2014 volume 2. So 788. You also get paragraph 44.
Yes. How does this look?
Yes, because the suit was filed on even Australian consider. The suit was filed under the renewal legislation.
After the institution of the suit, time for this is on a different footing. Please read para 44. That was on adverse coercion.
Yes, because coming to the case, the handler and appellant had filed a suit for eviction. The relief sought in the plaintiff's delivery of possession. It is not a forum that lacked inherent jurisdiction to pass a decree for delivery of possession.
This goes against you.
Yes, what is point from a lot? It's not the intention of the plaintiff to act or to take back the possession under these circumstances. After the institution of the suit, the time for acquiring title by adverse possession has been arrested to remain in the state of suspension. The entire proceeding arrest of the suit are terminated. Be it intimated that if by the date of present the suit defendant has already perfected title by adverse possession, the would stand on different footings. Now, this was observed on the basis of the
By the date of filing of the present suit, that is entirely on a different context. But the only line which you placed, the first two sentences goes against it. We'll rely on this. This is Mr. Datta's typical filter.
Just so you can go with G. 950.
For the sake of tenants, the order of return determination should be given to some other tenants. To save the tenants from the cruel landlords. No, we are not pro-tenant or pro-landlord. We are pro-law. Whatever is the law, we'll follow. If we got a single question of law, we'll definitely. Yes, what about this?
Now we are looking at term 825.
Their suit was filed for on the ground of trespass.
Yes. Well, however, defendant is trespasser and is sued as such, the situation would be totally different.
Which
The
para?
plaintiff
Which para?
filed suit having regard to the cause of action.
Which para?
Paragraph 25, my lord, your lordship, is a retrospective suit was filed.
There a suit for trespasser was filed. The eviction of trespasser was filed. In this case?
Yeah, no.
No, in this case.
No, another reconciliation. Your lordship, I can come to. The appellate defendant, my lord, your lordship can make find turn to paragraph 1. Cases that the landlord is claiming eviction of the tenant. On the basis of which, my lord, when, however, defendant is a trespasser, paragraph 25, and is sued as such, the situation will be totally different. The plaintiff must file a suit having regard to the cause of action thereof. The court is given case. More the relief having regard to the provision of Order 7 of the Code of Civil Procedure. The same provision cannot be applied in a situation in this nature. We therefore have the opinion that it is not a case whereby non-claim of issue or whether the appellant defendant was a trespasser or not. He was not prejudiced. Had such issue has been claimed, could have been brought on record evidence to establish that he has a prejudice. I cannot. Particularly in view of this fact, it has been held by this court below that he has not put in possession by the predecessor interest of the plaintiff in terms of the agreement for sale or other. If he has not been able to prove the agreement, he could have taken the other plea. That is, he was acquired by invisible title by adverse possession. He is said to have been in possession of supremacies for more than 12 years prior to the institution of the suit. The question as to whether defendant acquired title by adverse possession is also plea. He, in fact, raised the same before the appellate court submission made the appellate court by defendant that they have acquired title by adverse possession was merely argumentative. In nature, as neither there was a pleading nor there was an issue. The landed trial court has no occasion to go into the question of the opinion. But in that case, the nature issue required to be framed. After that, it was ultimately held. Paragraph 29. This requires to be done in a
But para 25 says when defendant is trespasser, plaintiff must file a suit having regard to the cause of action thereof.
yes. Here is the cause of action 2003.
The court in a given case can mold the relief, but cannot be applied.
Cannot be applied because my lord,
Your lordship again given 697. Fine. That's the week 3, my lord, your lordship, fine. 697.
Yes.
For the discussion made above, my lord will find that portion. The existing materials on record, and when the plaintiffs prove their title and ownership of the suit property were to exist proceedings. On the other hand, the defendant, as per the legal statement, failed to neglect to discharge his owners to proving his right of permanency in the suit premises, as the tenant or otherwise. Plaintiff suit must be succeed the findings of the learned counsel in deciding issue number 6 and 8, particularly the entails. Issue number 6 are not at all satisfactory and cannot be sustained in law in given transmission of the case. Thus, the irritable conclusion from the above discussion is that judgment degree so powerful learned counsel is not tenable in the law, and the plaintiffs are entitled to get degree for eviction against the defendant as a result of the appeal success on contest. So this was the contention for the purpose of deciding the issue. Now, my lord,
Why is there an issue required to be framed for whether he was a trespasser? Automatically the trespasser.
here my lord, said I have produced this tenant. I could have understood what is followed by lordship. Here my lord held that you are unable to prove your status, so you become a tenant. Another argument for the legislation. The lordship will turn to the appeal court.
No, but court has in the appeal court, para 12, court has discussed that plaintiff, he had contended that you were a tenant.
Yes.
As per verbal understanding, rate of rent was such and such.
We are unable to prove.
You, no rent receipt was showed, nothing was showed. That you made out a case that you are there on the strength of an agreement.
Agreement or it is?
So you are not. So you admit that you are not a tenant.
Yes. My case is that I am not indebted as a tenant. The court is of the opinion he is not an adverse person. He also not a license in the suit property. Then he has no other status but a tenant.
This finding is wrong.
So if this finding is wrong, why not then why not the entire suit based on the fact that the suit of the Premises Act or the way of reasonable retirement I required to be evicted. Then why not I could have filed produced the evidence on the adverse person on that. This is a cause of action.
Discussion was not taken by you.
No,
That is
because
not-
not a tenant after interstate under you. If you are not, this is the subject matter, well, the judgment which has been produced before the lordship also on the same fact. There's no issue of to that extent. I have the relationship between you and me, the tenant and not. Please stop. And please address and produce earlier before when your lordship sitting in Malad Banerjee.
In academics, what was the defense taken in this case before Justice Eviction? Let us see that.
Paragraph 6 subject to question, Malad.
That is the plaintiff's affair.
Yes, the responsible report and appeal against the mark of at level 7. The fail to prove the relationship landlord and tenant by between them, and the defendant not that the defendant has been let
It was a TPR case.
No, it was filed. This is why Malad, this is suit filed. The landlord tenant, if a logically turned to
Para 3 says he prior to the institution should also serve the notice.
yes. Issue number 6.
Yes, but what does it say under the Premises Act?
No, it is not on the premises.
It is under the 106.
Landlord tenant. They are also said that then it is a suit is trespassers illicit.
Then we don't understand this para 24. A simple tenancy can be terminated by service of notice under 106. Yes. Once a valid notice is served, tenant becomes a trespasser. Situation, however, has undergone a sea change. Then why does this come in after the Rent Control Act?
The state of West Bengal has also enacted the Withdrawal preemption act, got it that portion.
Yes, so how is it relevant if it did not take
And then about terminal tenancy does not become a trespasser, it becomes a statutory tenant. When, however, defendant is a trespasser or issues such notice, the situation will be totally different. The plaintiff must file a suit having regard to the cause of action thereof. The court in the given case, modern territory having regard to the provision of Order 7 Rule 7 of the Court of Procedure, but the same provision cannot be applied in the situation of this nature. We therefore have the opinion that if it is not a case whereby the non-framing of issue, well, that portion I have already guessed, the question as to whether the defendant acquired title by atrocious question was a possible plea. He, in fact, raised the same before the appellate court. Submission before the first appellate court by the defendant that he had acquired title by atrocious question was merely argumentative in nature, as neither there was any pleadings nor there was any issue. Learned trial court is an occasion to go into the said question. We therefore our opinion that in the case of this nature should be required to be
Let us see the issues. Your only ground for admission could have been that Mr. Bose's chamber is on the other side. Otherwise, there is no point.
issues were not
Let us see the issue, please.
page 96, 696.
No, we are just looking at the memo.
No, no, issue.
Case number 3.
See.
No, 696. No, issue again. Go. Page 3.
This is a case under the 1997 Act.
Yes. You are notified at the top. The defendant claims
6.
6 for notice of issue for notified.
But these issues are framed, your relevant issues are framed at the claim valid, got right title interest over the suit property, entitled to get a decree as paid. Any other release.
He is paying degree under the rate of
So
utilization.
5 is also there. Relief, the plaintiff is entitled to get the decree as per law and equity.
Law and equity means that
Not other.
is on the premises they say.
No defense, no sir. Your reasons.
Once one may draw questions to the earlier judgment, please, I have handed over to you.
Yes.
If you also can turn to paragraph 30.
$38.
ওই যে আগে থেকে এটা 14
$30, yes.
It is once simply analysis the principle stated in the efforts of the authorities, it is quite vivid that there is a difference in exercise of jurisdiction when the civil code deals with a lease relating to eviction brought before it under the provision of the Transfer of Property Act and under any special enactment pertaining to eviction on specific grounds. Needless to say, this court has cautiously added that if alternative relief is permissible within the ambit of the act, the position will be different. Therefore, the court can decide the issue of title if a tenant disputes the same, and only purpose is to see whether the denial of title of the landlord by tenant is bona fide in the circumstances of this case. We respectfully concur with the aforesaid view, and we have no hesitation in holding that the dictum laid down such and such. This is the earlier judgment, but distinguishable, and in the same case, the suit was filed under the Transfer of Property Act, where the equitable relief under orders of
So alternative relief could be granted.
after that one, it was held on that what is followed from a lot of that alternative Transfer of Property Act. At this juncture, we are obliged to state that it will depend upon the scheme of the act whether an alternative relief is permissible under the act. In such and such case, the learned just taking into consideration the width of the definition of landlord and tenant under the BR Building Lease Rent and Eviction Control 1982 has expressed the opinion. The dictionary clause under the act with which we are concurred herein is a similar expression. Thus, a limited inquiry pertaining to the status of the parties, relationship landlord and tenant could have been undertaken. Once the finding was recorded that there is no relationship of landlord and tenant under the scheme of the said act, there is no necessity to enter into the inquiry with regard to the title of the plaintiff based on the sale deed or title of the defendant as put forth by way of assertion of law position. Till the learned appellate judge while upholding the findings of the learned trial judge that there was no relationship of landlord and tenant between the parties, there is no warrant to we appreciate the evidence to overturn any other conclusion. The High Court is justified to extend that no equitable relief could be granted in a suit instituted under the Act, but it is committed an illegality by affirming the judgment and decree passed by the learned trial judge. Because by such affirmation, the defendant becomes the owner of the premises by acquisition of title by prescription, and when such an inquiry could be done, has been entered upon, and no finding could have been recorded. In fact, the High Court has correctly not well.
Premises sentencing 1997. The Alcourt dismissed on that ground that it was not maintainable under PC.
Yes, because there is no relationship, and by way of the documents are produced and intentions of are produced, it is not a change. Paragraph 32 will find for the motion.
Mr. Rai will admit the appeal and will hear him, and after hearing him, we intend to dispose of the appeal and at this stage and give him liberty to file a suit under the regular. Yes, what do you say on this? The frame of suit was under 97 Act.
Yes, sir. But in the cross-examination, the defendant admitted that he was a tenant under the grant. Case number 37 of the stay application. Case number 37. Since 1980, I used to reside in the house of Ramraj at Vidhanpuri as a tenant. On the basis of that, the appellate court, point number 12, page number 9, we decided that then he has no other status but a tenant, and this fact has been admitted by the defendant during his cross-examination while deposition as DW1 in his evidence.
Well, which page?
Which page? Page number 9.
Yes.
It's the last part of Mr.
Yes.
Then he has no other status but a tenant, and this fact has been admitted by the defendant during his cross-examination while deposing as DW1 in his evidence. He has clearly admitted that since 1980, he has been residing in the house of Ramraj Printing at Vidhanpuri as a tenant. And issue number 3, it was decided in favor of the plaintiff, and that has not been challenged by the defendant. And the plaintiff is the absolute owner of the property. Then what is the status under the Constituency Act? Nature of status.
You are looking at page 5.
And transfer of patra is not a different like segment. And it was decided in the issue number.
At least deposition.
Case 37, this is the last. A cross-examination. That in this case, on my behalf, Narendra.
Yes, as a tenant.
And there is a last line.
We have seen the last line. Yes, Mr. Rai.
Yes.
You're
You are logically 82. One kind country done on page 5 of the transfer judgment and the findings of the appellate court judgment. Done on page 5 of the transfer judgment. On the contrary.
Yes.
On the contrary, claim the defendant is possession. So this possession is subject to subsequent execution of this document. Anything is not.
No, but in your cross-examination,
82 and this is 93. That is why I'm trying to ask.
Once you enter into as a tenant.
After that, if you're not that is a point, a portion which has been placed before the lordship. Then the subsequent agreement does not cover up that status. If I am a tenant, after that you have
Clear agreement without any file, it is admission action immediate. An agreement does not confer in present time.
so for the status, what will
You admitted your status in
Yes.
1980 once, unless it is severe, that status remains. We missed out the next sentence in the appeal court judgment itself. No, Mr. Rai.
If you lordship once you
On the basis of that, it was held that he was.
if you lordship may kindly consider consideration is 37 my lord is 50.
Yes, yes. Since 1980, I used to reside in the house of Ram Rajas as a tenant.
West Bengal, present time age 65. At the time of 1965, I was used to stay.
Because we appreciate evidence here. Admission is there, that has been referred to by the appellate. We are not going to the evidence per se, but the appellate court has referred to that, and on the basis of that, we just missed the next sentence. That is our fault.
1980 used to reside in the house of Ramraj and Vidanpalli as a tenant.
Yes. On the basis of that, it has been held. We miss out the next paragraph because of this. The present second appeal has been preferred by the defendant in a suit for eviction, inter alia on the ground of reasonable requirement, as well as other grounds under the West Bengal Premises Tenancy Act 1997, comma, against a judgment of reversion. Which the next para, the learned trial judge, comma, while observing that the case of tenancy has not been proved and the suit does not come within the ambit of the 1997 Act, comma, dismiss the suit. On the other hand, comma, the learned appellate court, first appellate court reversed such judgment by observing that in view of the admission of DW1 in his cross-examination that he had been residing at the suit premises since 1980 as a tenant, comma, the status of tenancy was proved. Even otherwise, comma, the first appellate judge proceeded to hold that the ground of reasonable requirement had been established. So next para, learned counsel for the appellant argues that the very premise of the defense case was that there was an agreement between the appellant and the plaintiff stroke respondent to the effect that the plaintiff stroke respondent would transfer the suit property in favor of the defendant stroke appellant. Next para, thus, comma, that apart, comma, no rent receipt or other proof of tenancy was produced by the landlord before either of the courts below. Hence, comma, the learned trial judge, comma, on such premise had rightly dismissed the suit. It is argued by placing reliance on paragraph number 12 of the first appellate court's judgment that the learned first appellate judge held that the plaintiff had contended that the defendant is a tenant under him as per verbal understanding and the rate of rent was rupees 500 per month, and the defendant is not a lawful buyer, comma, nor in adverse position. He is also not a licensee in the suit property. Next para, it is argued that merely on the ground that the defendant had failed to prove that he was a lawful buyer, comma, by default, the first appellate court held that the defendant stroke appellant was a tenant, comma, despite the plaintiff having failed to prove such fact. Next para, it is argued that since the suit was framed under the 1997 Act on the cause of action that the defendant appellant was the premises tenant, comma, within the frame of such suit, comma, the ground of eviction on the basis of the defendant not being a valid title holder but a mere licensee could not have been passed. Next para, learned counsel places reliance on OMUC reported at 2009 15 SCC 693 and such reported at 2014 to SCC 788 in support of such proposition. Next para, although the court, comma, while hearing an appeal under Order 41 Rule 11 of the Code of Civil Procedure, comma, is not bound to give a hearing to the respondent, comma, that says there is no such bar in law if the court is of the opinion that for factual clarification, comma, hearing may be given to the respondent, comma, we decide to hear the learned advocate for the respondent on the limited question as to whether the appellate court could have passed such decree despite the tenancy having not been proved. So at this comma, learned counsel for the respondent, caveator stroke respondent, points out to the very next sentence in paragraph number 12 of the first appellate court's judgment, where it was observed that the defendant admitted as DW1 in his evidence that he was a tenant since 1980 in respect of the suit property. Next para, the judgments cited by learned counsel for the appellant are not apt in the context of the present case. Next para, insofar as Tribhuvan Shankar, apostrophe S, 2014. Case Supra is concerned, comma, the Honorable Supreme Court held that the appellant therein had filed a suit for eviction and the relief sought in the plaint was for delivery of possession, and as such, it was not a forum that lacked inherent jurisdiction to pass a decree for delivery of possession. It was held that it showed the intention of the plaintiff to act and to take back the possession, comma, under which circumstances, comma, it was held that after the institution of the suit, the time for acquiring title by adverse possession had been arrested or remained in a state of suspension. Next para. Although in paragraph number 30, it was held by the Honorable Supreme Court that on a seemly SWMLY analysis of the principle stated in the authorities discussed therein, comma, it was quite vivid that there is a difference in exercise of jurisdiction where the civil code deals with a LIS relating to eviction brought under the provisions of the Transfer of Property Act, and that under any special enactment pertaining to eviction, comma, in the final analysis, comma, the Honorable Supreme Court clearly observed that in a suit for eviction, comma, the relief of delivery of possession could be granted despite the frame of the suit. Next para. Insofar as Vishwanath Agarwala Supra is concerned, comma, the observations of the Honorable Supreme Court cannot be held to be a precedent in the present context. Next para. In the said case, comma, the suit was filed under the Rent Control Act. In paragraph number 24 of the judgment, comma, the Honorable Supreme Court observed that a simple tenancy can be terminated by service of notice under Section 106 of the Transfer of Property Act, and once a valid notice is served, comma, the tenant becomes a trespasser, comma, whereas under the Rent Control Act, comma, the tenant, comma, upon termination of tenancy, comma, does not become a trespasser but becomes a statutory tenant, comma, in which context, comma, the Honorable Supreme Court asserted that the principle of molding of relief could not be applied, comma, since no issue was framed specifically as to whether the defendant was a trespasser therein or not. Next para. Undoubtedly, the said judgment would acquire relevance in the present case if the learned appellate judge had observed that the case of tenancy could not be proved by the plaintiff. Next para. However, in such circumstances, comma, it might have been argued by the appellant that since the suit is couched and framed under the 1997 Act, comma, a specific rent control statute, comma, a decree of eviction on the ground of license might not have been passed. However, comma, in paragraph 12 of the impugned judgment of the first appellate court, comma, it was categorically observed that the defendant had no other status but a tenant, comma, which fact had been admitted by the defendant during his cross-examination while deposing as DW1, where he had clearly admitted that since 1980 he had been residing in the house of Ramraj within bracket the plaintiff bracket close at Bidhanpalli as a tenant. Next para. Thereupon, the First Appellate Court applied the principle embodied in Section 116 of the Evidence Act and held that the tenant is not permitted to deny the title of the landlord. Next para. Thus, in the present case, it is not that the case of tenancy was disbelieved, but still an eviction decree was passed under the rent control statute. The First Appellate Court, in the present case, categorically observed on the premise of the admission of the defendant stroke appellant as DW1 that he was a tenant in respect of the property and as such passed a decree under the 1997 Act. In the process, although the learned First Appellate Court had observed that the defendant had failed to prove his case of lawful buyer or any other status in respect of the property, such findings are mere obiter dicta insofar as the crux of the consideration before the courts below is concerned. Next para. Hence, in the present case, the trappings of the 1997 Act were fully applicable in view of the factual finding of the First Appellate Court, on an appreciation of the evidence, that the defendant appellant had proved his status as a tenant, admitted his status as a tenant. In such view of the matter, the eviction decree under the Rent Control Act, that is the 1997 Act, was perfectly justified, and the arguments of the appellant cannot be accepted. In such view of the matter, ACT 26 of 2024 is dismissed under Order 41 Rule 11 of the Code of Civil Procedure. Can one of 2020 what are pending? Can one and
One is
who was allowed? Yes, two were allowed.
Can one stay?
Can one stay? What is can see?
Substitution.
Accordingly, can one of 2024 stands dismissed as well. First of no rest of cost. Thank you. He saved us. Otherwise, we are going to have a wrong point. Deficit code fee. Mr. Das, you took in the deficit code fees. প্রথম লাইনে একটা করে দিন, the deficit code fees shall be put in by learned advocate for the by to law.
Item number 31.
For the very first time I saw it.
Very first time,
That will find color.
you are for the appellant.
Yes.
Others. So with serve and copy. The appellant shall serve a copy of Can 1 of 2025 on the respondents, indicating that the matter shall be listed under the same heading in the monthly list of February 2026, which the appellant shall file an affidavit of service to that effect on the return.
Item number 32.
Yes. The name of respondent number 2 does not find place in the first statute. This is against order,
Certified copy.
but his name is there in the plaint. Have you annexed a copy of the plaint?
Yes.
Very good. This is the section 5 coming up for the first time.
No.
Will directly be served copy? Quite possible. Will directly be served copy again.
Certified copy.
Why new certified copy?
As there was a defect was showing that the respondent number 2's name was not appearing on state.
Need not. Because this is an interlocutory order. this is not the final decree that that name would be missing. No. We need not help here. Appeal will probably ignore this defect. The deficit court fees have already been put in. And as such, the defect in that regard stands cured. Although the additional stamp reporter has given a report that the name of respondent number 2 does not find place in the cause title of the impugned order, we find from a copy of the plaint of issue annexed to the connected application that the respondent number 2 was a defendant in the trial court. As such, the said second defect pointed out by the stamp reporter is be ignored, and it is deemed that the said defect also stands cured. Next para, the appellant shall serve copies of Can 1 of 2024 on the respondents, indicating that the matter shall be listed under the same heading in the monthly list of February 2026. The appellant shall file an affidavit of service to that effect on the return.
Item number 33.
Yes.
All the defects which are curable by me, I am.
Some defects even to go to the trial court.
My lord.
For the other defects, it has to go back to the trial court.
Yes, my lord. My lord, initially the primary issue, my lord, involved in this appeal, my lord,
Yes.
amongst others, whether a parta whole property or trust property can be declared as a absolute ownership right.
You are the defendant or the plaintiff?
I am the defendant and appellant here,
You lost in both the courts.
my lord.
Their suit was for declaration of title.
No, they are sued directly, my lord, sued for eviction.
You are a trespasser.
I am the co-beneficiary of the property, my lord. I am the, my lord, daughter, I am the son of daughter.
What
The
is their-
original refugee family.
What is the plaintiff case? That you are a trespasser or a licensee or what?
No, they are saying, but the trial court holds that I am a licensee.
What is the plaintiff case? What is their case?
Plain case is that, my lord,
You are a trespasser or licensee or
licensee.
licensee?
Yes.
Very good. What was your defense? Now tell us.
Now, my lord, fact is required to be, my lord.
Fact means your defense.
Yes, my lord, I'm
Your fact is your defense.
yes, my lord, I'm saying, my lord, one by one. My lord, initially, the fact is, my lord, initially, my grandfather, Rai Kishore Rai, came from the East Pakistan. Thereafter, my lord, came from the East Pakistan with, my lord, 3 sons, including the father of the respondent and my mother, and 5 daughters, including my mother. Thereafter, my lord, after coming from the East Pakistan, the government by the scheme, my lord, started to process, my lord, rehabilitation. But in the meantime, in the year 1975-76, my grandfather died, my lord. In his absence, my lord, the patta was issued in the year 1989 in the name of father of the respondent, being Korta or head of the family, who shall hold the property, being trustee for all the beneficiaries. Now, my lord, the position is that after the death of the father of the respondent and after death of my mother, the respondent appeal are the co-beneficiaries. Now, my lord, one government order is very necessary to.
Your mother was married at the time when the patta was given.
No. Now, my lord, they are claiming the right from their father, and I am claiming the right from my mother.
They are claiming exclusive right.
Exclusive.
But
right.
you say that patta has to be held by his father on behalf of all the beneficiaries.
All the beneficiaries.
How was it dealt with by the court? Why was your plea turned down?
Yes, my lord.
Appears to be the law. What you are saying appears to be the law. How was it turned down?
Now, my lord, before my lord going to the, my lord, court order, the impugned order, my lord, I want to rely on the kindly, my lord, comes to the what is the scheme is saying. What is the scheme is saying? It is a special scheme, my lord. My lord, kindly come to
Refugee rehabilitation scheme says it will be held by on behalf of the others. Well, let us see this scheme.
my lord, the page is, my lord, 77 and 78. It is, my lord, the document which I can, my lord, collect, the type copy is next to 79. But I am reading, my lord. May I read, my lord?
Yes.
The undersigned, it is a, my lord, 81 government order. The undersigned is directed by the order of the governor to say that as a measure of rehabilitation of displaced families, homestead plots are being allotted to the GS colonies or squatting in approved squatters colonies where are being regularized
with the clear intention that the beneficiaries of all the of the allotment will be all the members of the family on record, though the allotment order was issued in the name of one member of the family as Karta or de facto head of the family, who might have been the eldest brother or else as per composition of the family as recorded at the time of allotment of the plots. Now, my lord, although the allotment could not and cannot be made to a family in the abstract sense, it follows and it is confirmed that the allotee in a case obtained the allotment order on behalf of the other members who are shown as a comprising family. My lord, thereafter, my lord, after filing this, my lord, appeal, my lord, I made an, my lord, RTI application to the department. I am handing over that copy to the my other.
No, new document.
But it is necessary because my kindly rely
We cannot look into new document. Sorry. If you do
in this document, my lord,
might have been, you have to file a regular order for 27 once we admit it. We cannot just look into that.
yes. Now,
This
my
is
lord,
not a writ petition. In a second appeal, we cannot just look into documents.
now, my lord, if my lord kindly come
So
to
how
the
are they dealt with by the courts below? Let us see the appellate court.
trial court order, my lord.
No, appellate court.
Appellate.
The judgment of affirmance, let us see how.
Appellate court order from starting from 43 page of my lord state petition. Now, my lord, kindly come to the page 40, page 46 of my stay application, my lord. The last paragraph, 1, 2, 3, third paragraph. My lord, may I read, my lord?
The internal page
Internal page, my lord, 3.
of the appeal court.
1, 2, 3, 4, my lord.
At the bottom, you find the page.
Yes. 2, 3, 4, my lord, 4.
Yes.
4, my lord, third paragraph.
Yes.
It is against the decision of the trial court as mentioned above. The defendant appellant preferred this appeal on the ground that the trial court did not apply judicial mind and failed to appreciate the evidence and material record. The learned trial court failed to appreciate that even if the deed of gift was executed, but a deed of gift is executed by the father of the my lord, defendant to me, but it is my lord admitted it was unregistered. Because my lord, I am residing with my uncle, that is mama, that is father of the respondent from my childhood, my lord. I have constructed therein, my lord, my construction. I have mutated properly, my lord. The deed of gift was executed in the favor of Niranjan Kumar Roy, that is their father. Being the father of the respondent and their predecessor interest hold the property in the suit as a trustee of the entire family as per notification of the, that is the geo, my lord, which I have relied. So, my lord, I have asked the geo, my lord,
on the basis of that gift deed, the appellate court proceeded on the premise that as if you have admitted their title and
no, they are, my lord, in the after filing the suit, they have, my lord, objected the gift deed. But it is the gift deed which is given in my favor, executed in my favor, though it is unregistered. My lord, gift deed is appearing at page number, my lord.
Not that. The appellate court proceeded on the premise that the gift deed is unregistered, that's why you don't acquire any title.
Yes.
But by accepting that gift deed, by producing that gift deed, you admitted his title because one having title can only give a gift.
Yes.
That was the premise on which the appellate court proceeded.
But my lord, the same cannot, my lord, bypass the statutory provision.
You are right. This appeal will be heard on the following substantial questions of law. One, whether the courts below proceeded on an erroneous premise, by overlooking the relevant government order number 2492/17 rehab arta capital 2 capital P for partner -82/79 dated April 23, 1981, in holding that the father of the plaintiff/respondent acquired absolute title in the disputed property, despite the settled law that in schemes for allotment to squatters, refugees, the allotment made in favor of the head of the family is deemed to be on behalf of all the other members of the family. Next, Roman 2, whether the courts below failed to adhere to the well-settled legal dictum that there cannot be any admission against the law, inasmuch as the government order dated April 23, 1981 has the force of law, and merely by admitting the execution of a deed of gift by the predecessor in interest of the plaintiff in favor of the appellant, comma, the appellant did not, the appellant could not be precluded from challenging the exclusivity of the title of the said predecessor of the plaintiff, namely Niranjan Kumar Rai. Any interim application?
Yes, my lord, stay application, my lord, is there, my lord, paying for stay of.
Yes, what do you say in the stay application?
Lord, may I only invite your lordship's attention to page 51 and 52 of their stay
No,
application.
no, no.
Because this is where this objection has been dealt with by the Lord Appellate Court below.
Maybe
That is why.
we'll hear the when we hear the appeal on bench, we'll hear.
Because our
Whatever
execution
we-
has been already filed, my lord. And
You have given the number.
I remember the number is, my lord, I have stated, my lord, para 33 of my application, miss case 15 arising out of TX number 1 of 23.
In your stay application, you have not paid for stay of execution. Yes, you have paid.
Yes, my lord.
In view of the appeal having been admitted by on substantial questions of law, comma, a sufficiently strong prima facie case has been made out. Accordingly, there shall be stay of all further proceedings. In what is miscellaneous case?
Miscellaneous case 15 of 23, my lord.
What is that under which provision?
My lord,
Arising out of
for execution.
execution is title execution case number. What is the miss case?
My lord, sir, thank you, my lord.
Yes, can you tell us what is the miss case about?
I am not informed.
Very good. That the execution is taken. Stay of all further proceedings in title execution case number 1 of 2023 pending before the court of the learned civil judge junior division at Vidhan Nagar district North 24 Parganas, as well as all connected proceedings till disposal of the appeal. So can 1 of 2025 can 1 of 2025 is allowed. The can 1 of 2025 is accordingly disposed of without any orders to cause. First up, in view of the appearance of the you are appearing for both the response. In view of the appearance, you lost the caveat. In view of the appearance of the plaintiff's respondents by dint of caveat, comma, service of notice of the appeal on the said respondents is dispensed with, and the vakalatnama filed in connection with the caveat be deemed to be the appearance of the respondents in the appeal as well. So, next para, the trial court record shall be brought by special messenger at the cost of the appellant to be deposited within a week from date. The appellant shall prepare and file the requisite number of informal paper books without comparing with the record within 6 weeks from the date of service of notice of the appeal on the learned advocate for the appellant. First up, limited the parties to mention the appeal before the appropriate learned single judge, then having determination for inclusion in the list as and when the appeal is ready for you.
The defects, my lord.
The records be sent down to the trial court in the meantime. Achana, the decree of the certified copies of the impugned decrees be sent down to the trial court in the meantime for the purpose of correction in terms of the additional stamp reporter's report. Sorry, we did not hear you, but in second appeal, normally don't have a right of hearing. Because you are taking us to different documents, we cannot look into that at least. Take up the next one after that.
Item number 34.
None appears for the parties at the time of call. Let the matter stand adjourned till the next monthly list.
But also that not under order by the time updating the adequate copy of the document.
Face? Pardon? Use the mic. Take the mic towards you.
As per earlier judgment copy of the adequate policy, and submitting matter.
Yes, we'll keep it on record. No difficulty. 150,000 you have also corrected.
When I pray for a short possible and
What about you? You have no right of hearing. No possible. Have you announced the plaint anywhere? No passover. Nothing whatever. Is the certified copy of the appeal code?
This minor
Yes.
last order was created. Decree of the
No condonation application. We condone the delay.
no my God, condonation application is there.
Actually, it is also there.
Can one.
2 days delay.
As per my entry, it is taken as 10 days.
What is the reason?
It's paragraph number 7.
Yes. What is the matter about appeal?
Already just got instructed from
Who is the senior? Which Mr. Mukherjee?
Mr. Mukherjee. English staff of Kotuma, Vivo Kotuma.
Short passover. We are passing it over.
My
To get your passover. Oh, you're there. Your junior was asking for passover. So we are passing it over for 5. Ask him to come immediately. Whenever he finishes there. Mr. Rai, please wait on. I mean, whenever.
my
Mention when he comes.
my
Item number 36.
Yes.
Not to my lecture here on behalf of the appeal point.
What is the defect?
Not to be very, but the appeal is not faster.
There is a section 5 application. Well, defect also you have to let us see.
Faster also the order was passed on April 2025.
There are several defects. You have to correct it. This is against a remand order or what?
There was an the appellate court first appeal also.
Yes.
The appellate the first the order was first after that the marriage was void also. And
Acha. They filed a suit, they got a degree, they lost.
they got a degree also.
Both the courts will have held in their favor.
In the first matter also,
In the first court, they lost.
they lost. Then they preferred an appeal.
There they won.
Their prayer
There are
was
several defects, please correct the defects. Memorandum of appeal from original degree of it. Should be appellate degree.
Lordship, as per the direction of instruction from my senior lordship, already all objections have been complained.
You are there.
Yes.
Please check up. There are 3 defects mainly. You will the moment you look at the report, you will understand.
Yes.
First of all, memorandum of appeal from original degree should be appellate degree. With the second appeal, a degree signing date of both the courts below need not be given.
Original degree has already been handed over to you.
Not that. You don't understand also. Classification of the appeal is memorandum. In your memorandum, you have written memorandum of appeal from original decree. It should be appellate from origin appellate decree.
Yes.
First. Secondly, the as per order 20, the date of the judgment is the date of the decree. In your preamble of the memorandum, you have written judgment dated such and such and decree dated such and such. And decree dated such and such will be the decree. Do those things. And wrong list of documents furnished at the foot of the memo. That you have corrected probably. List of anyway, you check up and come back tomorrow. Just rectify. This is a section 5. There is no section 5. If you correct during the course of the day, we can hear the appeal right now.
Can you take it on tomorrow? There's so many.
Not too many. You move the appeal. We'll give you liberty. Then remove it. We'll give you liberty to correct during the course of the day.
Yes.
Even if you lose, please do the corrections. Even if you lose the appeal, even if you dismiss the appeal, please, we are giving you leave. Honor that.
Then after correction, I have to come on tomorrow.
No.
Yes. I understand.
Leave is granted to the learned advocate on record for the appellant to carry out the necessary corrections in terms of the additional stamp report at report dated July 18, 2025 during the course of the day. Subject to such correction, the appeal is being taken up for hearing. Subject to the document, the appeal is taken up for hearing. Under Order 41 Rule 11 of the Code of Civil Procedure. Yes. What is it?
This is the first order. The Lordship, the first order. This is the first order passed on Lordship.
They filed a suit for what? Nullity?
Yes.
What is the declaration sort? Let us see that.
The Lordship please to consider page 11 and the operative portion of page 22.
It was under the Special Marriage Act.
Yes.
What is the premise for holding that this is not a valid marriage? No marriage was held.
There will be certain issues with university that the notice was not served properly and on that day it was not present. He was in the employee of the PISF was not present and the person and the certificate, marriage certificate officer that the certificate was issued. These are the issues.
Special Marriage Act, Special Marriage Act. So what is your ground for challenge? Why is it wrong? Both the courts will be held against you.
Second, the first time the petition was dismissed, the plaintiff was dismissed. The second, thereafter they have challenged that order. That was the declared as the order.
Appeal courts, the trial court's certified copy you have handed over. The trial court certified copy, you have not filed the trial court certified copy. Trial court has been indicated. Up to zero. Appeal court is certified copy. Did you file trial court certified copy separately?
Yes, sir.
When? What is the entry number?
The 2 days, sir. As per the instruction for the authority. Lordship, may I check the file and thereafter Lordship?
No, you file the certificate. If the certified copy of the trial court is not with you, then you have to file it. I mean, you will require time to get the certified copy from the trial court. যেটা আগে বললাম যেটা বললাম যেটা বললাম তারপর লাস্টে শেষ করে তারপর বললাম যে এই সেন্টেন্সে কেটে however we further find that the certified copies of the judgment and decree of the trial court have not been filed along with the appeal, and as such, the appeal is defective on such count as well. Full stop. Leave is granted to the appellant to file the certified copies of the judgment and decree of the trial court within a fortnight from date. Full stop. Next para. Let the appeal go out of the list for the present with liberty to mention as and when the defects are cured. One out of list for the defect cured.
They are doing one for invalid.
Yes.
Speak to fix it. Otherwise, it not to speak to because they said that.
No.
They are trying
File the certified copy of the trial court and immediately after filing, get it reported by the office and then mention. We'll take it about.
It will take. They will not.
You, whatever time you take for getting the certified copy, call on the
It
next
was
day.
handed over. It was
Item
not-
number 37.
Yes. There are so many defects. You are an old chamber, sir. You should have checked up. What is this against? Second appeal. You have written in the memorandum, caption is memorandum of appeal from original order. You don't check up. You should have checked up. You are sufficiently veteran for this. Classification is a preamble, no name of the learned judge is there.
I will rectify my lord.
Should have checked up.
In course, my lord.
Trial court's decree is not there. Same.
Shall go to the other parents.
You have annexed. Let us see.
Can you see? The weekly dated.
You find the judgment of the
And then both the.
appellate court judgment we have found.
Shall go.
No, trial court neither judgment nor decree certified copy. Certified copy is not there. Certified copy has to be, don't you even know that?
My family, see, my copy is certificate. That DJP to 734 of the.
Is that a certified copy? Is that called a certified copy? We knew it as a photocopy. Nowadays it is being called a certified copy. We find that there are several defects in the memorandum of appeal, comma, including that neither the certified copy of the appeal court's decree, first appellate court's decree, comma, which has been challenged before us, comma, nor the certified copy of either the judgment or the decree of the trial court have been annexed to the memorandum. Full stop. Accordingly, let the matter go out of the list with liberty to the learned advocate on record for the appellant to cure the defects. Full stop. Liberty to mention the matter after such defects are cured. Out of this. File certified, even the certified copy of the decree of the appeal court is not there.
I'm going to the record.
Next.
Item number 38.
Out of this. Therefore,
Item 38, Particular Penalty of the offense.
yes.
Mr. Chantal Bose is appearing in this matter. Some personal difficulty has been come to court today. However, can one is a section 5 application
Appearing for the first time.
appearing for the first time, Lord.
Very.
In serving her.
The appellate shall serve a copy of CAT 1 of 2025 on the respondent, indicating that the matter shall be listed under the same heading in the monthly list of February 2026. Push up the appellant shall file and the appellants shall file an affidavit of service on the return.
Yes.
No copy start to respond.
Because you have not lodged a caveat, you have to spend money for a caveat.
Item number 39.
Ma'am, you can give a letter, you have instruction to appear for the respondent.
On the respondent.
You can write a letter to her formally so that she can give the copy to you instead of sending by post. You have directed service. Yes, but you have to write a formal letter for that. Other matter called. Yes. Your service would be good if he appeared. You know that. Can section 5 is there. Sir will come back. The appellant shall serve copies of only on the respondent number 1. Very good. The appellant shall serve copies of CAN 1 of 2025 on the respondents, indicating that the matter shall be listed next in the monthly list of February 2026 under the same heading. Push up the appellant shall serve file an affidavit of service to that effect on the return. What's the direction of the court here?
Item number 40.
Yes. Yes, sir.
The last petition that is allowed section 5 application. They will not be mandates for 41.
You have respond. Respond.
My suit for eviction.
Yes.
Under the premises tenancy act got dismissed by both the courts. The initial.
It's a rare feat.
Yes. Initial, the contention of both the courts is that, that my notice to quit under section 6 is invalid. For that, may I just give your lordship 3 years? The notice was dated 28th of March 2013.
Milord, I just want to interrupt. By Mr. Preemption. It's not available at
You don't have a right of hearing at the order. If you admit that, then it goes.
So, the notice dated 28th of March 2013, it was received by the defendant,
That is Yes, 28th of March 2013, notice date.
Yes, it was received by the defendant on 30th of March 2013. And the plain file to file on 11th of June
2013.
Yes. But kindly takes up now the trial court judgment.
What is the language before? Since 4 languages.
One clear month notice is not essential. One clear month. I say, my suit is being filed not much after giving 1 month. Your lordship's court has laid down the law.
No, shall be instituted.
Yes.
No suit shall be instituted.
Yes. So institution of suit is being not signed here. Here, I instituted suit on 11th of June 2013.
Yes. So
Court below.
Yes.
Both the courts held. Cause of action given in the notice is 1 day.
one.
They got the notice. Kindly takes up internal page 7 of the trial court judgment. This issue. Internal page 7 the issue number 2 to 9 is being adjudicated.
Yes.
May I just place the second paragraph of page 7? According to the claim, the cause of action alleged to have been arisen on has been not
155.
that according to the learned judge is 1 day shortfall. But the cause of action is a bundle of that.
So 1 second. 30th of March.
28th of March, my notice date, and it was received by them on 30th of March 2030.
So why is it short? 1st of May. Shall we say unless he has given
It
one?
appears from I say my suit institution of suit is much after expiry of 1 month. That is the criteria. But both the courts held that my suit is bad because my notice under section 6 is not.
No, even if it is taken from the date of the notice, it was received on 30th of March. So 1 month elapses on 30th of April.
According to the learned judge, it is calculated 31st of that month. Then it will be on 2nd of.
No, it is not 30 days. It's 1 month.
1 month. So that's why not in both these points cover.
What are you saying? Let us see. Notice that this is in the statute that what is 30 days. It is a calendar.
According to the translation, can see next page, page 8, nearly the middle. My cause of action would have been start from 2nd of May instead of 1st of May.
How?
That is also wrong. Whether not in
30th of March is the date of knowledge. Even if you take the date of knowledge, 30th of March. Your notice is of 28th of March. You don't even take the date of the notice. When they receive 30th of March. So 1 clear month, 1 month's notice. Yes.
And my institution of
No, in the notice you stated that you will be. Let us see the notice once. The notice was received on 1st of April.
1st of April.
Another defendant.
Another. And not my institution of suit is not much after.
No, that's in any event. Have you annexed the notice anywhere? Or have you got a copy of the notice? You might have mentioned there that
Just make it up.
in the notice you must have stated that you must be within some. You must have stated that you'll have to vacate by year.
But it has been mentioned on page 8. In the notice, no date is mentioned regarding vacating of the premises by the defendant, so the notice is invalid and vague, and there is no cause of action properly mentioned in the suit. So even if that is also not necessary, your lordship's law is very clear.
This appeal will be heard on the following substantial questions of law. One, whether both the courts below, Roman 1-2,
Another thing that I want to just indicate, since your lordship is framing the substantial question of law regarding 7(1)(c), there is a non-compliance because within the period of 15 days of each succeeding month, that is 7(1)(c) language. But in respect of September 2014, the rent was deposited on 27th of October.
No, it was dismissed only on the
It is dismissed on the ground of notice, but since your lordship is admitting now the law is clear, you are by the Honorable Supreme Court. Even if 7(1)(c), non-compliance, no section 5 is attributable. Here, there is no.
No, we won't go into that question because if it is, even if we allow the second appeal,
No, that is
you are led by him.
And led by Mr. Pradip Bali.
Milords, I'm appearing. Milords, I'm appearing. Can you permit me to appear virtually?
Agree, will admit the appeal and dispose it up and set aside and direct the trial court to take up this suit from the stage of from the inception, because notice is a valid ground. We'll formulate the questions of law, and if you agree, we can dispose of the second appeal right now and send it back.
Milords, kindly grant me an opportunity to make submission. So,
then we'll admit the appeal. You don't have a right of hearing. Just admit it.
please, Milords, from paragraphs of the impugn.
No, we
Judgment in order, Milords.
cannot do that at the order of your stage. Very well. This substantial questions of law. One, whether both the courts below substantially erred in law in holding the eviction notice issued by the plaintiff stroke appellant under section 6 within bracket 4 of the West Bengal Premises Act 1997 to be vague in view of no particular date of vacating having been mentioned, comma, which is contrary to the well-settled law that notice cannot be construed with a view to find fault, and it is what the parties understood from the notice which is to be taken into consideration. Roman 2, whether, comma, in view of the language of section 6 within bracket 4 of the West Bengal Premises Act 1997, comma, both the courts below substantially erred in law in holding that sufficient notice of 1 month was not given, comma, in view of the notice being dated March 28, 2013, comma, received by at least one of the defendants on March 30, 2013, and the suit having been instituted long thereafter on June 11, 2013, comma, which dates satisfy the statutory requirement of a clear month between the giving of the notice and the arising of the cause of action. To sub next para, there is a stay application.
Since my suit for eviction got.
Oh, sorry. In view of the appearance of the respondents, we are appealing for both respondents, Mr. Bag. Both respondents. We are asking you, both respondents. Say, in view of the appearance of both the respondents to their learned advocate, service of notice of the appeal on the respondents is dispensed with. The trial court record shall be brought by special messenger at the cost of the appellant to be deposited within a week from date. The appellant shall prepare and file the requisite number of informal paper books without comparing with the records within 6 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Liberty to the parties to mention the appeal for inclusion before the appropriate learned single judge, then having determination as and when the appeal is ready for you. Password.
Deep privilege, Milords.
Item number 35.
Yes.
I just today, I have handed over the copy of the decree which was not done. Also, may I pray the
No. If you are not ready, why did you mention?
No, sir. Yes, sir. Also directed to cure that copy of the decree.
How does it give you a right not to be ready in the matter?
Lordship, the
No, you have filed the appeal court's what? Today?
decree, which was not effective, Lordship.
Any other defect is there, Mr. Mukherjee?
The name of the
We will just check. Valuation you have corrected. Delay of 2 days.
10 days.
There is a section 5 also. Mr. Rai, section 5. Which is the can?
One.
We will make it good. If you have sufficient explanation of the delay for the delay in preferring the appeal having been made out, can 1 of 2025 is allowed, comma, thereby condemning the delay in preferring SAT 116 of 2025. Question. The appeal is accordingly taken up. For hearing under Order Factor Rule 11 of the Code of Civil Procedure, upon deeming that the defects therein stand clear. Yes, what is that? Line after the certified copy of the judgment and decree of the trial court of the first appellate court filed today be kept on record. Yes.
Lordship, the one Forester Mukherjee was the original owner of the property.
First of all, you are the plaintiff or defendant, and what is the statement?
See, I am the defendant, appellant, Lordship, the judgment of application.
Suit for
Lordship, the suit for partition, declaration partition.
You are challenging a preliminary decree.
Lordship, the suit, yes, absolutely.
What is your point? Substantial.
Now, Lordship, the Forester Mukherjee was the original owner of the suit property.
Right.
Lordship, the Forester Mukherjee expired on 15th April 1990. Leaving behind, Lordship, the Manusi Mukherjee, Lordship, who is the wife, Omkit Mukherjee, at the relevant point of time, Lordship was a minor. Moumita Mukherjee, also minor. Lordship, Navanita, Lordship Mukherjee claimed as a Lordship the major at the relevant point of time, and Lordship Sorbani was major. The Lordship the 1994, Lordship the Madhusudan Das, who was the Borgadar of the concerned property, Lordship all these heirs, the Forester Mukherjee executed a registered sale deed.
Who executed?
Lordship the Manusi Mukherjee.
Manusi and the minors and majors all they executed.
Only now here is the point, Lordship. The Omkit Mukherjee and Moumita Mukherjee both are represented through Manusi.
In the deed.
In the deed. Lordship, Navanita Mukherjee, who represented as a major. Lordship, she did not represented through her minor, but she represented as an individual capacity as a major. And Lordship, Sorbani, Lordship.
So dispute is only regarding Navanita.
Nobody.
Sorbani
admitted Lordship major.
So they executed a transfer deed, sale deed.
Sale deed.
In favor of?
In favor of Madhusudan Das.
Right, then.
Now, Madhusudan Das in the year 2015, Lordship, he transferred the defendant, the present Lordship, the applicant. Now, present applicant submitted application for mutation before the concerned block land and non-refund.
Your deed was of 2015.
2015.
So when you applied, then what happened?
Now, a notice usually sent to Lordship the heirs of Forester Mukherjee, Manusi Mukherjee, Omkit and Moumita. All on a sudden, Lordship Omkit, Moumita and Lordship the Navanita filed this suit. Now, according to them, they were the minors, so this sale deed which was executed in 1994 is valid. Now, Lordship, the learned trial judge, Lordship, dismissed the prayer of Omkit and Moumita because they did not, Lordship, paid for cancellation of the within 3 years of their attaining the major. But Navanita, Lordship, who proved that at the relevant point of time, Lordship, I am a minor, but Lordship, her share has been 1/5 share has been declared.
Her share has been declared. No, she did not challenge the transfer deed.
She did not challenge the transfer deed, but
transfer deed was not set aside.
Transfer deed has not been set aside.
So then
he declared the share of Navanita at the relevant point of time. She was a minor.
No, share of Navanita in any event will be declared or transferred. Very understood.
Share of
so
Navanita.
The transfer in her respect was cancelled.
1/5.
So it was held that the deed could not transfer her share.
Her share.
Insofar as her share is concerned, she retained the same.
Yes. Then relying upon the Mohoribi versus Dharandas case.
So only Navanita was granted a degree
Yes.
by both the courts.
Both.
What is the ground of challenge? This is a factual question whether she was a major or a minor.
What is the deed she represented as a major? When Ankit and Momita represented through her mother, as a minor.
With Momita, no degree has been granted, so you are not agreeing.
And Navanita, Lordship, knowing fully well, the Lordship Manasi knowing fully well that Navanita was a minor, Lordship represented her as a major. So Lordship knowledge.
Navanita herself signed.
Navanita herself signed. Not through her mother.
How did the courts will proceed? What proof she produced regarding her minority?
Lordship, the document of the admit card of Navanita, Lordship, he produced, and according to the admit card at the relevant point of time.
But there is no estoppel against the law. That is the difficulty, Mr. Mukherjee. You
Now, Lordship, the knowledge.
Even if she knowingly signed, but if she was a minor in law, she could not.
Now, Lordship, so far the knowledge is concerned. Lordship, the Mohoribi Lordship Dharandas case.
What knowledge? Knowledge of whom?
Knowledge of majority and minority. Lordship, at the relevant point of time when in the year 1915, Lordship, 1994, Navanita was minor.
1994, the deed was in favor of Madhusudan was executed.
Yes, the Madhusudan was known that the Navanita was major because she represented individual capacity.
Maybe.
So when knowing fully well that a person is transferring deed and representing as a major, subsequently after
that is the principle of estoppel, you were saying.
Yes, so this is kindly considered.
Estoppel whether can operate against the law.
Yes.
Can a minor enter into a contract? Can a minor enter into a contract or a transfer deed?
The knowledge is very essential.
So what is your substantial question of law? On that she proved that she was a minor.
So first of all, both the courts are in law because at the relevant point of time she represented as a major. But after a long period, she claiming that I was the minor.
If it was the other way around, you could have had a valid case. If she was a minor, yes, she was a minor actually. Yes, you say that her claim is that she is a minor.
She is a minor.
So she could not. She ought to have challenged that. She did not challenge within time.
No, this is challenge after the execution of the second date, which was executed in our favor, in my favor.
Which is much after attaining.
Long time. This is my deed was executed.
According to her, when did she attain majority, Mr. Mukherjee?
Majority in 1995, 1 year.
But and the suit was filed in
2015.
2015. Yes, which paragraph of this?
The knowledge of estoppel, unless the knowledge is there in both parties, this estoppel does not happen.
So, any particular paragraph? Please the relevant portion. But here, estoppel was held in favor of the minor. Where money has been advanced to an infant with full knowledge of his infancy, court can, in the exercise of discretion conferred, refuse to order its return.
Yes, so knowledge is essential. So I have both the courts.
But here it is the knowledge of the minor, it is the other way around.
Yes, there was the knowledge of the minor. In spite of that, deed was executed. But here in this case, Madhusudan Das had no knowledge that she was minor.
Had no knowledge.
Had no knowledge. Because when other two minors is Lordship, represented through her mother, then what prevented Lordship the plaintiff to represent it through her mother, because she represented as individual capacity.
The facts of this judgment are different. So here, money was advanced to a minor. Now, it was observed by the court that there can be no estoppel, but truth of the matter is known to both parties. Minor knew, and this major person who gave the money also knew. Now, the person who gave the money is now challenged.
And also, I am the subsequent transfer.
Yes.
I am the subsequent transfer.
Subsequent transfer, it does not have acquire a better title than the your predecessor. That is not journal.
Kindly see the deed.
But two points may be considered. That the Nobonita challenged the deed much after attaining her majority, even admitted.
Yes.
And secondly, this estoppel, whether it can operate. Now let us say how the courts dealt with this. How did the appellate court deal with this?
Joseph, kindly come inner page 6. Yes, of the inner page 7, second paragraph.
No, here 3 years limitation would not be applicable because it was not that the deed was executed in favor of the minor. Minor herself executed the deed.
Lordship, the minor herself, Lordship, suffered the unki.
A minor can challenge a deed within 3 years from attaining majority.
This is not the case.
If that is not the case.
That is not the case.
Because if it was executed in her favor.
Yes.
Here it was a minor who executed the deed. Right? Now,
Onkit and Momita executed the
Onkit
deed.
Morgan, Momita forget. We were considering
Nobonita, Lordship, executed.
Nobonita, insofar as Nobonita is concerned, just listen to us for a minute. If Nobonita, it was executed in favor of, rather on behalf of Nobonita, then that 3-year limitation would apply. It was executed by herself. Now, therefore, the 3-year limitation attaining majority, that does not apply. Nobonita herself executed the deed. Now, estoppel, therefore, it is estoppel against Nobonita. Whether there can be estoppel against the law because a minor cannot execute a deed or enter into a transfer.
Yes. But Nobonita, Lordship, executed the deed as a major.
But it has been held by both the courts that it is proved that she was a minor. Therefore, now, as per the factual findings, she was a minor at the relevant point of time.
That is knowledge too in the year 2015.
Knowledge may be, your knowledge may be later. But your knowledge, the premise of your argument on knowledge is estoppel. Therefore, unless Nobonita is barred by estoppel from challenging that transfer, you don't have any case. Because fact remains that she was a minor. It has been held by both the courts that she was a minor when she executed the deed, right? Now, therefore, it's a question of her estoppel. Estoppel, whether it should operate against her. Now, whether estoppel can operate against a minor at that point of time, because there cannot be an estoppel against the law. Law says minor cannot execute a deed.
Now, Lordship, so far, Lordship, for the sake of argument,
Yes.
Onkit and Momita's right has been, Lordship, rejected on the ground because after the attaining majority 3 years, they did not previously kindly see the entire order of the charge.
No, there is a distinction between the two. Insofar as Onkit and Nobonita is concerned, sale deed was executed by mother on their behalf.
Yes.
They did not execute. So if mother executed, they took a point that no permission of the court was obtained. That was their point.
Yes.
You understand first what we are saying. We are speaking about two different branches of law, two different laws. One is estoppel, another is statutory bar. Now, as far as Onkit and Momita are concerned, they stand on a different footing than Nobonita. Why? Because mother executed the deed on behalf of Onkit and Momita. It is not that they themselves executed. If guardian executes a deed in favor of the minor, the minors can challenge upon within certain time after attaining majority. 3 years. Now, in their case, they challenged after 3 years. In their case, it is not them who executed the deed. Do you get our point? In case this 3-year bar is applicable in cases where on behalf of minor, their guardian executes the deed. So therefore, that bar was applicable to Ankit and Moumita. They did not challenge within 3 years from attaining majority, therefore it goes. But insofar as Navonita is concerned, she herself executed, representing herself to be a major. Therefore, the question which arises is not whether, because if the deed was executed on her behalf by her guardian, then the question of her challenging after such and such years should apply. Here it is not that case. Here, Navonita herself, at the point of execution, she has been proved to be a minor before both the courts. Therefore, it is the question of whether a minor can execute. Under law, a minor cannot execute a deed. That's well said. That flows from law. Now, therefore, you are now claiming estoppel against Navonita herself, not her mother. When Navonita, the minor at that point of time, she executed. Now, whether that estoppel operates against a statute, that is what we are saying. Statute says minor cannot execute. So, if you are to hold that Navonita is barred by estoppel, that estoppel would be against statute, law, which debars a minor from executing a transfer deed.
And
Your
Navonita also
your remedy would
represented herself as a major. Navonita herself represented as a major, and after a long period of the second transfer, she claimed that this transfer was not.
What you are saying, that comes within the purview of, that is precisely the definition of estoppel. That if somebody makes a representation, you act on that representation to your against your interest, then I am estoppel. If I give out a representation, you act on that, and then you suffer for that acting, then I am barred by estoppel. Estoppel operates against me because on my representation you did something. Here, Navonita represented something, and you did something on that basis. So estoppel otherwise operates against Navonita. Definitely would operate. But since both courts have held that she was a minor at that point of time, now for estoppel to operate, here the estoppel is regarding whether she had the right to transfer. In law, she does not have the right to transfer. Suppose Navonita made out some other representation, which is not barred by law, then we could understand. But here, estoppel, there cannot be an estoppel against the law. You cannot say that you are estopped, because that estoppel would operate against the law. A minor does not have the right under law to transfer, but she gives out that I have the right to. So therefore, she should be otherwise barred by estoppel. Whether that can operate against the law, that is what we are asking you.
I'll also kindly consider that after a long time, because 94 and 2015.
So 1/5 share of Navonita was not transferred in your favor.
That is the lawsuit court said.
So rightly, I mean, you could have asked for damages against Navonita for that if you have suffered damage for that 1/5. But title could not pass. Minor could not confer a title.
Also, kindly see that deed lawsuit which was executed.
In your reasoning portion, while dismissing your appeal under Order for Rule 11, we put in a line regarding damages. We might have asked for damages, which will be damaging to Mr. Reyes because of his conduct. But we'll have to dismiss in Order for Rule 11. Sorry. We'll put in something damaging because this is, I mean, 17 years old, gave out to be minor. Our conscience is not satisfied, but judicial conscience goes by laws. So we cannot go beyond that. Yes, anything else you want?
Also, I am just showing you the deed lawsuit which was executed.
How will that help you? She executed the deed, giving herself out to be a major. Wrong done against you, definitely. At best, damages. We are passing our order. The present appeal has been preferred.
One day lawsuit.
No. The present appeal
More
has
to be mentioned.
no. The present appeal has been preferred against a judgment of affirmance comma, whereby the trial court passed a preliminary decree of partition, comma, which was affirmed by the first appellate court. To sub next para, the backdrop of the case is that one Parishnath Mukherjee, comma, the original owner of the suit property, left behind his wife Manoshi and 4 children, namely Onkit, Momita, Nobonita, and Sharbani, as his heirs and legal representatives. First up, a transfer deed was executed by Manoshi, comma, for herself and on behalf of the minor son and daughter Onkit and Momita, and by Nobonita and Sharbani in the year 1994 in respect of the suit property in favor of one Madhusudan. Question next para. The said Madhusudan transferred the suit property in the year 2015 in favor of the defendant stroke present appellant. Question next para. In the subsequently, Nobonita filed the present suit for partition and also challenged the deed of transfer executed in favor of Madhusudan insofar as Nobonita's share is concerned. Simultaneously, comma, Onkit and Momita also challenged the transfer deed on the ground that the same was executed on their behalf by their mother, but not for their benefit, and without any valid permission from a competent court of law. Next para. The courts below, comma, while turning down the challenge of Onkit and Momita to the transfer deed on the ground that they challenged the same beyond the statutory period of 3 years from attaining majority, comma, the courts below upheld the challenge of Nobonita, comma, despite she having executed the transfer deed in favor of Madhusudan as well as a major, comma, on the ground that on the basis of materials on record, comma, Nobonita established that she was still a minor when the 1994 deed was executed by her. So accordingly, comma, by the impugned judgment and decree, comma, both the courts below declared 1/5 share of Nobonita in respect of the suit property, whereas did not disturb the title acquired in respect of the other 4/5 share by the present defendant appellant by the deed of 2015. So next para, learned counsel for the appellant argues that insofar as Nobonita is concerned, comma, in view of her having executed the transfer deed herself, comma, on the representation that she was a major on that date, comma, she was bound by estoppel from challenging the said deed long thereafter, comma, particularly in view of the subsequent transfer deed having been executed by the transferee of Nobonita, namely Madhusudan, comma, in favor of the defendant appellant in the year 2015. Who's up in support of his contention, comma, learned counsel cites judgmented namta party in Mohori reported at volume 8, Roman 7, sorry. Roman 7, CWN 441. Footstep next para. Upon hearing learned counsel for the appellant, comma, we find that the ratio laid down in Mohori BB, BIBEE, Supra, is not applicable to the present case. Footstep in the said case, comma, it was held that there can be no estoppel where the truth of the matter is known to both parties and a false representation made to a person who knows it to be false is not such a fraud as to take away the privilege of infancy. Footstep in the facts of that case, comma, it was held that where money has been advanced to an infant with full knowledge of his infancy, comma, a court can, in the exercise of discretion conferred on it under the relevant sections of the Specific Relief Act, comma, refuse to order its return by the infant to the other party. Full stop. Next para. However, there are two gross distinction between the facts of the said case and the present litigation. So, first, in the said case, the principle of estoppel was sought to be applied against the infant, against the person who had made payments in favor of the infant. So, secondly, it was held that unless both parties had knowledge, there could not be any estoppel. So, next para, in the present case, the infant, the minor Nobonita, at the relevant point of time, had full knowledge of her minority, but despite the same represented herself to be a major. So, next para, that apart, the question as to whether the principle of estoppel operates against the law was not discussed or adjudicated in the cited judgment. So, next para, in the present case, the principle of estoppel cannot be applied against Nobonita for the simple reason that at the relevant point of time when the transfer deed of 1994 was executed, Nobonita has been held by both the courts below on appreciation of evidence to have been a minor. Next para, law provides that a minor cannot enter into a contract and consequentially a transaction in respect of an immovable property. Next para, hence, in order to apply the doctrine of estoppel against Nobonita, the said operation would be contrary to the law in respect of minors not being competent to enter into transactions. In view of the settled proposition of law that there cannot be an estoppel against the law, thus the contention of the appellant on the premise of estoppel against Nobonita cannot be accepted. Next para, at best, for Nobonita having executed the deed by giving out herself to be a major, although still a minor, on the verge of attaining majority, the relief of the plaintiff, defendant stroke appellant could lie in damages. Thus, there is nothing precluding the appellant to claim damages in that regard insofar as Nobonita is concerned, and if so sought, the same has to be adjudicated in accordance with law by the appropriate court, including the court where the partition suit is now pending. Next para, however, fact remains that the impugned judgments and decrees of both the courts below cannot be set aside on the ground as taken by the appellant. Accordingly, we do not find any substantial question of law involved, particularly since the question of minority of Nobonita is purely a question of fact, which has been adjudicated concurrently by both the courts below on the basis of the evidence on record. Hence, SAT 116 of 2025 is dismissed under Order 41, Rule 11 of the Code of Civil Procedure. Consequentially, Can 2 of 2025 stands disposed of as well, no rest course. The certified copy of the judgment and decree of fees. Good. Can one combination of right.
Item number 41. We also had allowed adjournment on the ground that there are defects in the matter.
Yes.
We have applied for certified copy in the law court, but we have not used.
So not only that, classification of application.
Classification, we have rectified the motion on
Yes,
the-
yes, you have.
Just that the ordinary decree of the trial court and decree, certified copy of the decree of the court of appeal.
This goes out of the list whenever you obtain, we'll give you.
You must kindly
We
allow.
cannot keep it in the list indefinitely. We are not being able to add other.
One more opportunity.
No.
Short.
So, learned counsel for the appellants seeks further time to file the certified copies of the judgment and decree of the trial court and the decree of the first appellate court. So we find from the records that on December 8, 2025, such opportunity had already been granted. So next para, accordingly, let the matter go out of the list with liberty to the appellants to mention for inclusion in the list as and when the defects are cured by filing the omitted certified copies. একটা সেলাই প্লে স্টোরে একটু করিয়ে দেবেন একটা কোনো সেলাই প্লে স্টোরে
Item number 42.
Yes. You take your seat first, Mr. Chatterjee, and we should not hear you on the microphone. Once we hear you on the microphone, dismiss. Yes. Yes, sir. Mr. Mitra, you are there. Yes, Mr. Rai, what is the matter?
To file under section 22 subsection 1 of the bill such as for preemptive transfer.
Captain actor আছে? Yes, please continue. You are the plaintiff.
And the victim. Procedural 11 file rejected because they preferred an appeal. Appeal court set the order of rejection. Is that manner?
Appeal court set aside the
Order of rejection of procedural level of the parliament. Then
you are the defendant. Your 711 was
allowed.
Because
they preferred an appeal.
They preferred an appeal. That was appealable. But appellate court in effect dismissed the order 711.
Yes.
This is revisable.
But
Right? This is revisable.
Appeal court revisable.
Effect of the appellate court's order is that the 711 is rejected. Therefore, does not come to the purview of decree under section.
Now on serious basis.
Yes, said to the contrary.
Subjective
Side three judgments come back tomorrow. Since the question of maintainability of the appeal has come up for consideration, comma, to enable learned counsel to for the appellant to meet the same, comma, let the matter stand adjourned for the day.
Item number 43.
Minute in item number 43, I beg to minute appear on behalf of the appellant.
Yes. You are for the appellant?
Yes, Miller. Yes.
Mitra, you are also for the appellant. This is which what versus what? What is the name of the parties, Mr. Banerjee?
Then Miller, I must have minute commit a mistake.
No, that cannot be a foregone conclusion.
I would be happy if I was
Well, this is Arijit Dosh Mollik versus
No.
Neelam Dubey. Oh, Miller, I'm sorry. I'm so sorry, Miller. I'm so sorry.
That is 44. Yours is 44, Mr. Banerjee. Yes, Mr.
I'm so sorry, Miller. I'm sorry. I'm sorry.
Mr. Mitra, there is some defect. Let's take up. Several defects. Mr. Mitra, judgment and decree certified copy of the trial court is not there. So that is a defect you cannot ask him to cure right now. Other defects you learn at adjournment.
Can I minute the judgment?
Judgment and decree, certified copies of the judgment and decree
Of the trial court, yes.
of the trial court, yes.
In any event, my lord, I would have pressed for time because my lord, my bill did not contain that.
Yes. Apparently, our defect also doesn't contain. So, but the other defects your advocate can cure. One is preamble is bereft of the name of the learned trial. No, trial court details are not there. In ejectment, appeal number such and such. Nothing is given. No, this is nothing is in format, Mr. So just ask some. You take appropriate guidance and just. It cannot be like this civil appellate side civil appellate. Memorandum of appeal from what you have to write. List of documents mentioned in the memo is not in proper order. Several things. Memo of appeal needs to be classified in words. First is it says.
I shall not waste your lordship.
No, Mr. Mitra, unless you file the certified copies of the judgment and decree, the evaluation also cannot be asserted. We'll ask it to go out of the list and mention it immediately as soon as you file the certified copies of the, and we'll give your advocate and liberty to make the other correction in the future. We find several defects in the appeal, Pushar, insofar as the filing of the certified copies of the judgment and decree of the trial court is concerned, the appellant is directed to file those at the earliest, as and when obtained. Pushed up, leave is given to the learned advocate and record for the appellant to rectify the other defects in the memorandum of appeal during the by tomorrow. Pushed up, next para. Let the matter go out of the list with liberty to mention as and when the defect regarding certified copies of judgment and decree of the trial court is cured. The other defects you can cure by tomorrow. Thank you.
Item number 44.
44 I have made.
44.
This is my app.
So when you will start after the recess? It's
Yes, yes.
We will start again.
Item number 44 will continue.
I,
I'm
Minute I beg to appear.
Yes.
Minute I beg to appear, Minute, on behalf of the appellant. Minute,
Right.
this is an appeal, Minute, from an order allowing, Minute, an application under Order 22, Rule 10.
Section 5 is there.
Yes, Minute, Section 5 application is there. Minute, there was, Minute, a delay of 345 days, Minute, in filing the appeal because, Minute, before filing the appeal,
Appearing for
Minute,
the
mistakenly a review.
appearing for the first time.
I'm told, Minute, yes.
He directed to self copy and conduct.
Very good. And Minute, there are some defects. Minute, kindly also allow us, Minute, to cure those defects, Minute, in the meantime.
So you
And
serve-
Millard,
can-
we need to file Millard order 41 Rule 27 application. If Millard kindly permits us, Millard, to do that also.
we have the liberty in law. Then if you want to do that, then we'll keep
Wait,
it there.
wait,
Month.
wait,
Can do that. Can
Wait.
do can see are there in both the appeals? The appellant,
yes, Millard, yes.
that is 3. That is what we asked you.
Yes,
That is there in both the applications.
Yes, but the appeals, my lord, let that be allowed, my lord. Plaintiff number 2, the pro forma respondent number 2 has it. That substitution, we are.
No, the I and substitution have to be taken up together because there is no appeal in the area of law on this. So the appellant shall serve copies of Can 2 and Can 3, Can 2 of 2025 and Can 3 of 2025 filed in connection with both the appeals. And file an affidavit of service to that effect on the returnable date. The matters shall next be listed. The matters shall next be listed under the same heading in the monthly list of February 2026. Due to appeal action order.
And Millard, liberty to cure the defects, Millard, in the meantime.
Liberty is given to the learned advocate on record for the appellant in both the matters to cure the defects in the meantime.
So grateful, Millard. Grateful to you.
Item number 46 to 49.
For the appeal. In the last suggestion, your lordships were pleased to direct to file affidavit of opposition with regard to the matter application for injunction in the core appeal. But if that matter no opposition is filed by the defendant.
We need one more week. Which is the stay has already been granted upon them on the previous of the bill. So we need one more week to affirm the affidavit submission as there's a medical emergency or on the part of respondent number 1.
Very well. An extension of time for filing affidavit in opposition is sought by learned counsel for the respondent number 1 on the ground of medical emergency of the said respondent. So, accordingly, the time for filing affidavit in opposition is extended for a week from date. Reply, if any, shall be filed within a week thereafter. The matter shall next be listed under the same heading in the monthly list of February 2026. Right.
46 to 49.
But yes.
Exactly.
None appears for the parties at the time of call. Let the matter stand adjourned and be listed next in the monthly list of February 2026.
Item number 51.
Before the applicant maintains his whole beneficiary, he only makes a painful short possible.
No. Put the matter. Is there any caveat? No, there is no very possible. Mention whenever he comes.
Item number 52.
Put out of the place, which will the proposed to have a for selling data. One of the application. None appears for the party at the time of call. So, let the matter stand adjourned, be listed in the monthly list of February 2026.
Item number 53.
Same.
Item number 54.
The appellant challenging and ex parte ad interim order of injunction. May I file my affidavit?
What about the fate of service?
My lord, two addresses have been given by the plaintiff in the complaint. One address just been said to be insufficient address came back. Another, my lord, it shows that served at the case source.
Issue is of good service.
That is why my lord I mentioned it.
Did we admit the appeal previously? What are the applications for?
My lord, application stay.
Appeal was admitted.
No, this is for the first time.
Then why did you ask me to serve?
My lord, I first became my lord, ex parte ad
You
interim.
carved up your own.
Yes, my lord.
No, unless you admit the appeal.
I
Affidavit of service filed to be kept on record. Which of
My lord, may I only indicate to what happened to your lordship? 2015.
No, we'll take up the appeal.
Wait,
Order. Affidavit of service filed to be kept on record. So it appears therefrom that proper service has not yet been effected on the respondents. However, in any event, the appeal has not yet been admitted and there was no direction to serve. Accordingly, the appeal is taken up for hearing under Order Rule 11 of the Code of Civil. Yes. What is the application?
My lord, 2015, my lord, I filed and instituted an eviction suit against my tenant, Mr. Dismissal. Decreed on 28th August 2025.
Eviction on ground of
Eviction on the ground of default and
the premises tenancy.
primarily default. Now, thereafter, my lord, in November 2025, I received a notice from the plaintiff in this suit, in the subject suit, that he should not be dispossessed from the premises, and he is the
You obtained the
declaration that the judgment and decree dated such and Barracoot is not binding upon the
all right.
and ex parte ad interim order was obtained from by him. My lord, he has claimed that the tenancy was transferred by my tenant against whom the eviction decree has been obtained by me in the year 1999 with the consent of my predecessor from whom I purchased the property. Now, my lord, to prove that prima facie, to prove I am going by absolutely his plain case, to prove that, my lord, he has relied on an agreement at page 41.
Yes.
Kindly come to my lord, page 44. Second paragraph.
Yes.
আমার আর্থিক অসচ্ছলতা ও নানাবিধ কারণবশত উক্ত দোকান ঘরে উক্ত ব্যবসা আমার নামে পরিচালনা করা সম্ভব না হওয়ায় আমার উক্ত দোকান ঘরের ভাড়াটিয়া সত্ত্ব দোকান ঘরের গুগলি এক্সেট্রা সম্পত্তি 3,70,000 টাকা মূল্য ধার্য করত হস্তান্তর তথা বিক্রয় করবার কথা ঘোষণা করিলে আপনি অস্ত্র দ্বিতীয় পক্ষ ইহা উক্ত ধার্যকৃত মূল্যে গ্রহণ করিতে ক্রয় করিতে ইচ্ছা প্রকাশ করিলে আপনার উভয় পক্ষ নিম্নলিখিত সাক্ষীগণের সাক্ষাতে নিম্নলিখিত শর্তে
This was executed prior to the institution of your previous suit. Much prior.
1999 this was
But at this point of time also you were the owner.
I purchased the property.
No, you obtained the eviction decree against Vishnu Vishwas on the premise that he is a tenant.
He is a tenant.
Acha, Vishnu was tenant under your predecessor.
Under my predecessor, and I say that from 2000 he has not paid the rent.
No, this was executed in 1999.
Yes, my this was executed on 1st January 21st January 1998, and I purchased on 10th March 1999.
All right.
He has relied on, the plaintiff has relied on another document at page 49. which showed that Mr. Expeditious had written a letter to my predecessor. And I should indicate to your lordship, my lord, at the bottom, left hand side of the bottom,
Yes.
there appears to be a signature, my lord, we are in the identity stage.
Of that predecessor.
Far from
Yes, you have to go by their case.
I am going by their case. Even this does not show at the highest, it can be shown that it was received. It does not show it was consent. Now, my lord is aware of consent and information.
No, but personal service is personal service.
Well, personally,
If he agreed, I mean, if he signed that it is in the nature of preemption, at least an adjournment.
my lord, subject to correction by your lordship, it would be an adventure on my part to explain the difference before your lordship, the difference between consent and information.
Yes.
Going by the plain case, I am for the time being, I have to accept that it was received by my predecessor, who is a proponent here also. The statute says,
This is which section?
well, section 5, subsection 6 of the Procedural Consistency Act.
97? Right.
May I read for your lordship?
Yes, please. Yes.
No tenant, it's an obligation of the tenant.
Previous consent, right?
Yes.
So this cannot be in any will be, even if this was consent, this was not. So this is not a valid transfer. Therefore, you say it doesn't have a privacy case. But if at this stage we state in
Along with that.
yes,
Now, second limb of my argument,
yes,
being if he is a tenant, for the time being, I have to accept that he is a tenant, he says. 5.1 says every tenant shall pay rent to the landlord or his authorized agent within the prescribed period.
right.
So he just made payment of rent to either my predecessor or to his authorized agent or to the rent controller. He claims that the rent controller receipts in his name, page 51. Kindly come to page 51 once. My lord, will you please to find the number of the proceeding HRC to be filed by HRC number 319 of 2000. Payment is being made by Procedural, son of such and such. That is the plaintiff. For the month of right hand side, for the month of second line, my type copy second line from the bottom for the month of April and May 2025. Now, my lord, what document was I have already also filed another application order 41 rule 27. I obtained information slip with regard to that proceeding. But kindly come to page 87 and 86 first. First 86.
Yes.
Well, the proceeding was instituted by Mr. Procedural. Now, what amount of rent will pay? ₹20, last payment, such and such date. That page 51 date. And kindly come to the next page, page 87. The proceeding was instituted in 2000, in the year 2000, and who had filed the proceeding? Mr. Injunction.
No, but will it be the same proceeding?
Yes, page 51. I'll categorically check page 51.
All right, yes.
So even going by the plaintiff's case here, one, no previous consent of the landlord has been obtained. So he cannot be a tenant.
Although the proceeding was initiated by Vishnu, the first page of the information slip shows it was deposited in the name of the present plaintiff.
Minor inspection has been taken till March 2020. It shows Vishnu, then April and May.
And then some privacy case has been made out by.
Minor privacy case, he has to show previous consent. Had this document page that later page 49 had yes consented to. আমাকে আগে জানিয়েছিল
Not there.
not so prima facie he has to satisfy this honorable court.
Yeah, we will admit the appeal, but
I say today we are in the addendum stage. But may I try to perhaps my learned friend is appearing for
you're appealing for this
the plaintiff. But may I try to make the subject correction by your lordship?
Yes.
Little suggestion. Let me file my written objection there and let the learned court below dispose of the injunction application within a period of 3 months.
that will. Very well. You give a copy to him. He have got a copy.
Yes, I have got it.
So that service was good service. Okay. Heard learned counsel for the appellants who subjects para. The present appeal has been preferred against an adjudicating order of injunction restraining the defendant of appellants from dispossessing the plaintiff's respondents from the suit property.
Respondent number 1.
As a plaintiff stroke respondent number 1 from the suit property by executing the judgment and decree obtained by the present appellants in ejectment suit number 56 of 2015 passed by the learned civil judge junior division second court at Barrack. To sub next para, learned counsel for the appellant contends that even as per the case made out by the plaintiff stroke respondent number 1 in his plaint and written statement and the annexures thereto, the plaintiff relies on a purported letter of adjournment written to the original landlord, that is the predecessor in interest of the present plaintiff, present defendant's appellants, which was apparently received by the said landlord. So it is argued that that section 5 within bracket 6 of the West Bengal Premises Tenancy Act 1997 contemplates that no tenant shall, without the previous consent in writing of the landlord, transfer or assign his right in the tenancy or any part thereof. Next para, it is argued that the purported document referred to above can at best tantamount to a receipt of the information given by the plaintiff stroke respondent number 1, who subsequently, subsequent notice of a transfer by the tenant in favor of the present plaintiff stroke respondent number 1 cannot tantamount to previous consent clause, which is mandated under section 5 within bracket 6 of the 1997 Act, thus vitiating the very premise of the tenancy claimed by the plaintiff stroke respondent number 1. So next para, secondly, it is argued that even from the information obtained from the rent controller's office, it appears that initially a proceeding for deposit of rent was made by Vishnu Vishwas, the original tenant against whom an eviction decree was obtained by the appellants, and only for 2 months, rent was deposited in the said proceeding in the name of the present plaintiff stroke respondent number 1. So thus, it also appears from the admitted documents that Vishnu Vishwas retained his tenancy even after the date of the transfer deed relied on by the plaintiff stroke respondent number 1. To sub next para, heard in view of such questions of fact and law being involved, comma, the appeal is admitted. To sub at this juncture, comma, learned counsel for the respondent number plaintiff stroke respondent number 1, comma, who is the main contesting party, appears and contests the application made in connection with the appeal. To sub next para, learned counsel for the appellant, comma, in his usual fairness, comma, submits that the appellants may be permitted to file the written objection to the temporary injunction application in the court below, and the injunction application be directed to be disposed of within a limited period, comma, by keeping all questions open, comma, since the scope of the present challenge is only in respect of an adjudicating order. Next para, we find substance in such contention. Although certain arguable questions have been raised in the appeal, comma, in view of the stage being premature, comma, any observations or conclusive findings made by this court while disposing of the appeal finally might adversely affect the interests of either of the parties in the temporary injunction application which is pending before the trial court. Next para, accordingly, comma, FMAT 494 of 2025 as well as the connected applications wherein can 1 of 2025 and can 2 of 2025 are disposed of by directing the defendants to appellants to file their written objection to the temporary injunction application pending in the trial court within a fortnight from date. Next para, the learned trial judge shall make all endeavor to dispose of the temporary injunction application upon hearing both sides as expeditiously thereafter as possible, comma, preferably within 4 weeks from the date of communication of this order to the learned trial court. Next para, in view of the disposal of the appeal and the applications in the light of the above observations, comma, we do not interfere with the impugned order dated November 3, 2025, passed by the learned civil judge, senior division, 3rd Court at Parashat, District North 24 Governors, in title suit number 1179 of 2025, comma, keeping all points open to be argued by the parties before the trial court. We make it abundantly clear that the merits of the respective contentions of the parties have not been entered into at this stage by this court, and the learned trial judge shall dispose of the temporary injunction application as well as the suit independently on their own merit without being influenced in any manner by any of the observations made herein or in the order impugned before us. No understand.
Your page 27, your suit is valued at 60,100.
Could have pointed out at the then the appeal is not maintainable.
Page 17 also, Miller.
Let us see the plain clause.
Page 27, Miller. Page 27, Miller can do.
Yes, this is not maintainable here.
And it's para 17, Miller.
Then this order, not maintainable. It have pointed out whenever it appears. It's a no, very well. Affidavit of service, full order type. Affidavit of service filed to be kept on record. Next para, it is pointed out by learned counsel for the plaintiff to respondent 1 that the appeal is not maintainable before this court due to lack of pecuniary jurisdiction. We find from the valuation of the suit from which the present appeal arises that the same is rupees 60,100 dash. Accordingly, this court does not have pecuniary jurisdiction to entertain the appeal. Upon at this comma, learned counsel for the appellants seeks to withdraw the appeal. Accordingly, FMAT 494 of 2025, along with the connected applications bearing can 1 of 2025 and can 2 of 2025 are dismissed as withdrawn without any orders to cost, whose it is made clear that the merits of the appeal have not been entered into by this. Leave is granted. Leave is granted to the learned advocate record for the appellant to take back the certified copy of the impugned order from the department upon furnishing a photocopy of the same.
I'm extremely sorry for
No, no, no. Fast and order.
Well, it is basically this.
No, whatever.
So urgent, it has lost its urgency, but it is already.
Yeah.
Well, these well, it is.
A fast and order, somebody might have been watching for the other side. We don't know.
Uh,
What order did you pass?
It was made of monthly.
You are the appellant.
Well, it is arising from a conflict paper.
Yes.
And from the guardian and guardian, it was his appellant to paper. But the appellant, he made a put up application with the interim application, and that application was fixed on 14th of January. Tomorrow is the date fixed before the.
You are to withdraw the appeal, we are permitting you that.
He says, there is nothing in this application.
If you say you will withdraw, we'll permit you to do that. Otherwise, we have in any event fixed it in the monthly list of February. When if it has become infectious in the meantime, point it out.
Then kindly fix it on monthly list of.
We have done that one.
Some defects are there, which are change free.
Whatever we do.
May I be permitted to correct the.
No further order. You
Right.
call on the passport.
Passport item number 51.
Yes, it's a valid. Actually, here also there is a question of maintainability. Let us see the report of this. What is this PMC case means? From junior division. No appeal lies before this court. You have to go with the district judge. In any event, district the maximum limit of pecuniary jurisdiction of junior division, you have to go before the district judge. Junior division, junior.
19 lakhs 80,000. It will not be.
How was it filed for the junior division?
It was filed by.
Preemption case under which provision?
Section 8 of the original.
It's an application in the nature of an application. Then how can we value it?
Valuation is made one of 20C. They are applicable by P1.
Whatever be the valuation, no appeal lies before this court against the learned civil judge junior division order. Then we will have to hold that the preemption case was not maintainable.
Yes. The points are also involved.
You have also taken that point.
I have taken only one point that after partition, when I purchased the property from the vendor and the person who has filed the preemption application, his father was also participating.
Preemption, whatever is the valuation put, Mr. Banerjee, it cannot be valued. It has to be valued like a mistake. So this valuation is irrelevant. It lies before the district judge.
Only thing is that my lord,
Go before the district judge.
if you become my lord, pecuniary limit is 19 lakh 80,000. District judge has been.
Appeal valuation of the preemption application is not determined by the whatever valuation is put by them. We'll hold that. Probably this is the consideration amount or what?
Consideration.
We find from the valuation statement in the memorandum of appeal that the same has been evaluated at rupees 19 lakh 80,000. What is the preemption application?
Page 40 of the application, connected application. Yeah. Valuation is given, my lord.
You have given this valuation.
No, they have also.
Where?
The currently counsel the paragraph 12.
Paragraph 12. That's the valuation of the transaction. Preemption suit is not evaluated like that. New things, you are teaching us new things. Yes.
We find from the mention statement in the
Such as that. Because however, comma, as rightly pointed out by the additional stamp reporter in his report, comma, the appeal arises out of an order passed in a miscellaneous case under section 8 of the West Bengal Land Reforms Act, comma, for preemption. First of the impugned order has been passed by the first court of learned civil judge junior division at Chinsuda district Hooghly. First of, as such, comma, the valuation cannot be in terms of the consideration amount for the sale sought to be preempted, but the preemption application is treated to be a miscellaneous case within the contemplation of the civil rules and orders framed by this court. Post of next para, the appeal, comma, as such, comma, against an order passed by a civil judge junior division is maintainable only before the district judge and not before the concerned district judge and not before this court. Accordingly, FMAT 455 of 2025 is dismissed as not maintainable on the ground of pecuniary jurisdiction, with liberty to the appellants to prefer an appeal before the appropriate court having jurisdiction. Can 1 of 2025 is accordingly dismissed as well without an order to cost. The merits of the matter have not been entered into. Liberty is given to the learned advocate and record for the appellants to take back the certified copy of the impugned order upon furnishing a photocopy of the same. Thank you.
Item number 55.
There is a delay.
How much?
The section, the application was delayed 129 days.
Explanation, Mr.
If your lordship takes up my application, paragraph 3. That I have indicated because premise was that my application under order 39 rule 4 that was also not taken up for it. Why I advise for filing this appeal challenging the interim order granted because the plaintiff saying that by virtue of one notarized development agreement, he has a right to construct over my property.
Yeah, that will be considered. Yes, what about the section 5?
Section 5 was initial, but otherwise, I want to objection to section 5. But my lord, kindly see my lord, paragraph 3b. My lord, they say my lord, they paid money to one say customer who I don't know whether he's an advocate or not. And my lord, there is a admittedly they are filed.
Will not go by B, will go by C. Only C.
And they are filed vacating application. They are filed written objection.
These are different reviews.
Right.
But you are right in saying that filing of that could not be a consideration for the delay.
Right.
But we will go by C. We will record your. Right. In view of no affidavits being invited, comma, it is deemed that none of the allegations made in Can 1 of 2025 are admitted by the respondent. So, next para. The delay of about 129 days in preparing the appeal has been sought to be explained on several grounds, comma, one being that an application for vacating of the impugned ad interim order of injunction had been filed, which was not taken up for a considerable time, upon which a different person was contacted and steps was taken for preparing the present appeal. Full stop. Prima facie, comma, the pendency or attempts to file a vacating application cannot afford a ground for delay in preferring an appeal against the ad interim order, comma, since the two reliefs operate in different spheres. However, comma, in paragraph number 3 within bracket small c of the condonation application, comma, it has been pleaded that the appellant number 1 is a paralytic, is a patient of paralysis, and the appellant number 2 is a patient of occasional seizure. Next para, that apart, comma, appellant numbers 3 and 4, comma, the only other appellant, comma, have been claimed to be illiterate ladies. Next para, in such view of the matter, comma, this court is of the opinion that keeping in view that the appellants might not have been in a position to be too diligent in preferring the appeal in view of their conditions, comma, the delay in preferring the appeal ought to be condoned by taking a lenient view of the matter. Accordingly, can 1 of 2025 is allowed, thereby condoning the delay in preferring FMAT 511 of 2025. Yes, what is the appeal?
If minor family takes up the can.
An interim injunction granted should for
For declaration, to the effect that the kindly takes up the page 20 plain starts, kindly takes up once page 28. I say the primary relief is the prayer bill. In this, a decree declares that the plaintiff's right to develop the property based on the agreement dated 9th of January 2020. Others, in my respectful submission, is a consequential prayer depending upon prayer. Because his right
fair A is that contract is they are speaking of the same contract.
Same. This is
Prayer A is the primary.
But prayer A, B, is yes. But it's emanates
A
from
and
the
B are
agreement.
same. Yes.
So it's emanates from a development agreement.
Yes.
Can I clear that? Now, if you lordship without wasting your lordship's time any further, kindly takes up the agreement itself is at page 69 of my lordship. Just to remind you, Lordship, in 2001, there is an amendment of Registration Act incorporating section 71 capital A. Vis-a-vis, there are other amendments taken effect in the Transfer of Property Act also regarding section 53 capital. Some portion is being omitted and incorporation is being made in one capital. Kindly takes up this is a motorized agreement. I say this agreement itself, this instrument itself creating an interest or charge over the property that the Honorable Supreme Court has held. This kind of joint venture development agreement by virtue, because why? By virtue of this agreement, there are two separate allocation is being provided. One is to the owner side and other is to the developer side. And by virtue of this instrument itself, the developer is being targeted to create third-party interest coupled with the power of attorney. That is the tenor of this agreement also. It becomes mandatorily registrable after incorporation of one capital. If you are not place,
they are the developer.
He is the developer.
You are the owner.
One, because there is two amendments taken side by side,
Registration Act. Yes.
One capital A, may I read for your lordship?
In the special bench judgment also there was a
special bench it clarifies that yes, it is an instrument creating interest. I shall show the Honorable Supreme Court judgment itself. Now this has come. One capital A, may I just read? The document containing contract to transfer of consideration any immovable property for the purpose of section 53 capital A of the Transfer of Property Act 1882 shall be registered if they have been executed on or after the commencement of the registration and other related laws amendment Act of 2001. And if such documents are not registered on or after such commencement, then they shall have no effect for the purpose of the said section 53 capital A. This what is the effect?
But this is only for the purpose of 53.
I shall place the Honorable Supreme Court has made clear this document itself does not create or confer any title over the property. So if that be so, the entire premise of granting injunction is based on this document, this instrument. And
they have not sought for specific purpose.
They have. Kindly takes up prayer B. That's why I have a decree declaring that the plaintiff's right to develop the property based on the recommended. This is nothing but a special performance of that. And if your lordship takes up this amendment was brought on with effect from 20.
So this is a decree that they, by virtue of the agreement itself, they have a right. They have not sought for specific performance of that contract by you.
But I say,
These operate in different fields.
I say, the effect of 53A, I will come.
53A only comes in if you want an eviction or
Honorable
something.
Supreme Court said this instrument itself is an inoperative instrument. Because why, Miller? If registration is mandated, Miller, now section 24 of the Registration Act gives a timeline by virtue of which, Miller, this has to be presented for registration. If that
But
timeline,
Mr. Mukherjee, the language is very specific. The documents containing contracts to transfer for consideration any immovable property for the purpose of section 53 capital A shall be registered if they have been executed or so for the purpose of section 53A and they have no effect for the for the same purpose.
exactly,
So it's
Miller,
entirely confined to
53A also, Miller, comes in A if they are asking for an injunction over my property.
একবার transfer property.
Miller, I shall learn that also.
If it is a defense,
But I prior to this 53 capital A,
yes, part of it.
then notwithstanding, may I place from that place, then notwithstanding that where there is an instrument of transfer, that the transfer has not been completed in the manner prescribed thereof by the law for the time being imposed, the transferor or any person claiming under him shall be debarred from enforcing against the transferee and the person claiming under him any right in respect of the property of which the transferee has taken or continued in possession other than a right expressly provided by the terms of the contract. Provided that nothing in this section shall affect the rights of the transferee for consideration who has no notice of contract or part performance thereof. Now, prior to this, if Lordship takes up the note, the word the contract, though required to be registered, has not been registered. This portion is being omitted. Why? By the same amendment on 24th of September 2001. This portion is being omitted because in substance of 1 capital A in the registration act, 17(1) capital A. The effect is being given by Balbir Singh judgment. What is the effect of this incorporation of 1 capital A and deletion of these words from the 53 capital of the transfer of property? Both this amendment has been taken care of by the Honorable Supreme Court in Balbir Singh. This was reported in 2018, volume 12, SCC, page 3.4. I shall place this also. So, your Lordship has got one portion, I may suggest that this 2001 amendment, kindly see, comes back to the Registration Act 17(2) small 5. We may omit sometimes because we are always taking aid of section 49 of the Registration Act, that the agreement for sale, regarding the agreement for sale, because of the proviso to section 49, it's not registered. But
in a specific offense suit, it need not be registered.
Need not be even registered after this, because small Roman 5 kindly takes up section 17 subsection 2 small Roman 5. This also incorporated in 2001. Here, any document other than a document specified in subsection 1 capital A, not itself creating, declaring, assigning or limiting or extinguishing any right, title or interest of the value of 100 rupees and upwards to or in immovable property, but merely creating a right to obtain another document which will then executed, create, declare, assign, limit or extinguish any such right, title or interest is not registered. So, in 2001, there is a sea change apart from section 49. The legislature has made it clear that subsection 1, the mandatorily registrable issue, will not be applicable in respect of the agreement for sale, because that is not creating itself, the instrument is not creating or extinguishing any type, but merely giving a right to execute another document. And if
this development agreement also gives right to create another.
No, there you are. That's the Supreme Court made it clear that here this is an instrument which is coming under the category of 1 capital A, because this instrument itself is creating title.
Title is conferred by virtue of that only. They can sell their portion. Their
Without
portion is
disturbing, yes. Allocation, I shall go before your Lordship. That's both part of the agreement also. And vis-a-vis section
Regarding their portion, landlord does not have to confirm. There's the
because they are the owner.
there's a transfer in presently.
Yes. Transfer is presently giving a right to me to develop, not only to develop, there is an allocation of.
You are the developer.
I'm the owner.
Yes, that's what we are
Yes,
saying.
yes.
The right in present is given to them by you.
Yes.
No,
No.
this 2(5) is the exception.
It's the exception.
In these cases, it is not.
Yes.
But this again accepts 1A.
One.
Therefore, 1A is not accepted. That is what is
Yes. Yes.
Other documents are accepted.
Yes.
So 1A, then we come back to 1A
Yes.
by virtue of 2(5). 1A says the documents containing contracts to transfer for consideration. But then how is 1A applicable? Because you are saying in the same breath that it's a transfer of right in presently, insofar as their portion is
And
concerned.
if it is not,
Then it's not a contract to transfer.
it's no, that it's what it's written, the document containing contract to flood. It's always, like, even if a conveyance, it's a contract. Ultimately, look, it boils down to an instrument. Whether that instrument requires registration or not, that is below the law of one capital.
No, the moment the conveyance is executed, Mr. Mukerji, you cannot agree with you that it remains in the domain of a contract or agreement. It's a present transfer deed.
Yes.
It's a deed of conveyance. A deed of conveyance cannot be said to be a contract of conveyance.
Exactly, Lord, what is in the present case also. Lord, kindly, Lord,
Now, in the same breath, how can you say that it conveys present title and that it's a contract to transfer?
Lord,
Insofar as their portion is
document containing contract to transfer. Lord, it's not in future transfer. It's a transfer.
Contract
At
to
the same
transfer means
breath.
contract to transfer means contract for the contract to transfer. To transfer means in future. Contract to transfer.
Any immovable property for the purpose.
Otherwise, it will come under the transfer under the heading transfer deed, instruments of transfer or deed of conveyance.
Transfer.
Past performance also relates to, if you say C53A, where any person contracts to transfer for consideration any immovable property by writing, so that can be a defense. If contract to transfer meant that transfer deed, then there would be no distinction because they would be the owners of the property.
In the
53A operates only if there is an agreement to sell, agreement to transfer. If it's transferred, then what is the necessity of 53A? The transferee becomes the owner.
Here, I say this particular joint venture development agreement, so that for the time being, the case in hand before your lordship is not a contract to transfer. Not a case, that it's a contract to transfer. This is what I say, that I will try to satisfy before your lordship. This instrument is itself, according to me, is a transfer.
Yes.
If that be so, it's mandatorily registered. And if it is mandatorily registrable, now kindly take up section 24 once. Sorry, take section 23. Subject to the provision contained in subject to the provision contained in section 24, 25, and 26, no document other than a will shall be accepted for registration unless presented for that purpose to the proper officer within 4 months from the date of its execution. So I say today it's a perennial defect, not curable. But I am conscious with regard to the stamp duty part under the Indian Stamp Act. But here, this is a perennial defect. He could have corrected this by presentation within the timeline given under section 23. That also lapsed. So today, it's a dead law. He cannot claim any right over a property showing this instrument before a court of law. Now, to elaborate this, may I just rely on this reported judgment? 2018, volume 12, SCC, page 354. Kindly takes up paragraph 5 because it's my duty before your lordship to point out some facts also whether this will satisfy the my lord's test with regard to the applicability. The respondents, as you lordship, the respondents before us are members of Punjabi Cooperative Housing Building Society Limited. The society consisted of 95 members and was the owner of such and such acre of the 500 square yard plot were held by 65 members, 1000 plot by 30 members, and the remaining 4 plots of 500 square yard each were being retained by it. The home contention of the present appeal is a tripartite joint development agreement dated such and such for the development of 21.2 acres of land in village such and such. This joint venture development agreement was entered into between the owner, that is Punjabi Cooperative Housing Building Society Limited, Harsh Building Private Limited, such and the Tata Steel, who undertake to develop 21.2 acres of land owned and registered in the name of the society. The agreed consideration was to be disbursed by such and such through Harsh to each individual member of the society, and different amount of the flats were to be payable and allotable to the members having different plot size. The developers were to make payment in 4 installments. The tenor of the development agreement is being narrated. Now, kindly comes to paragraph 8.
Yes.
The learned counsel for the revenue has argued that the assessing officer, the CIT, as well as the ITA were all correct in bringing capital receipt under JDA to tax as capital gain. According to learned counsel, the present case is squarely covered under section 247(5), as section 53 capital A of the Transfer of Property Act 1882 is applicable to the transaction under JDA. According to the learned counsel, the transferee in the present case has a part performance of contract taken possession of the entire property under JDA and has done various acts in furtherance of the contract, such as paying EMD and the first 2 installment, as that the transferee was willing to perform this part of contract will unfortunately could not ultimately be performed because of the order passed by the High Court because of the unnecessary permission for development of this property could not be obtained. He further argued that in fact after 2001 registration of agreement under section 53 capital A is necessary in law would not stand in the way, as section 247(5) only refers to contract of a nature of section 53 capital A, which your lordship was not having, of the transfer of property, and that therefore ITAT was right in stating that the section 53 capital A had been incorporated into section 247(5) of the Income Tax Act. It was unnecessary for the purpose of the Income Tax Act to have such an agreement registered. He further argued that ITAT was correct in finding that the possession had in fact been handed over by the JDA, as otherwise THDC would not have been authorized to amalgamate the project with the other project in the adjacent to the adjoining area. Well, I am not traveling now. Paragraph 19 kindly takes. I will not place the law regarding the 19 initial part, but my lord kindly see paragraph 20, 53 capital A, the transfer destination under the Income Tax Act, as well as lord, the incorporation of one capital A is being considered in page below paragraph 20, 21 and 22. 22 milord. Now may I place 22 and 23, that is the ratio. It is also well settled. It is also well settled by this court that the protection provided under section 53 capital A is only that field and can only be resorted to as a right of defense. Such and such is being quoted, an agreement for sale which fulfilled the ingredients of section 53 capital A was not required to be executed through a registered instrument. The position was changed by the Registration and Other Related Law Amendment Act of 2001. The amendments were made simultaneously in section 53 capital A of the Transfer of Property Act and section 17 and 49 of the Registration Act. By the aforesaid amendment, the word "the contract, though required to be registered, has not been registered," or so that this was within inverted comma in section 53 capital A of the 1882 Act have been omitted. Simultaneously, section 17 and 49 of the 1908 Act have been amended, clarifying that unless the document containing contract to transfer for consideration of any immovable property for the purpose of 53 capital of 1882 Act is registered, it shall not have any effect in law other than being received as evidence of a contract in a suit for specific performance or as evidence in a collateral transaction not required to be effected by a registered instrument. Section 17 capital is now not quoted. 49 of the Registration Act is also being quoted. Now paragraph 23 is important. The effect of the aforesaid amendment is that on and after commencement of Amendment Act of 2001, if an agreement like joint venture development agreement in the present case is not registered, then it shall have no effect in law for the purpose of section 53 capital. In short, there is no agreement in the eye of law which can be enforced under section 53 capital A of the Transfer of Property Act. This being the case, we are of the view that the High Court was right in stating that the order qualifying as transfer of a capital asset under section 2.
Mr. Mukherjee, this is not a section 53A scenario at all.
I'm coming up to that.
At all.
Because today,
you have a better case if you say that there was a transfer, present transfer by virtue of this.
that's my case.
Otherwise,
Section
section 53A, section 17, these are immaterial. Here, they are not using it as a shield.
No, that's why.
Why are you citing the judgment and 17 and all these things?
Because second part of this paragraph, the Honorable Supreme Court made it clear that
this was in the context of the Income Tax Act, and for that purpose, capital gains.
But the effect of this instrument is being not clarified.
For the purpose of section 53A.
I'm coming to what is not given in paragraph 23 at page 370. At 370, not the second line, this expression cannot be stretched to refer to an amendment that was made in the year latter in 2001, so as to then say that though registration of the contract is required by the Amendment Act of 2001, yet the aforesaid expression of a nature referred to in section 53 capital A would somehow refer only to a nature of contract mentioned under 53 capital A, which would then in turn not require registration. As has been stated above, there is no contract in the eye of law in the force under section 53 capital A after 2001 unless the said contract is registered. This being the case and is being clear that the JDA was never registered, since JDA has no efficacy in the eye of law, obviously no transfer can be said to have been taken place under the aforesaid document. Since we are deciding the case on the legal ground, it is unnecessary for us to go into the other question decided by the High Court. So I say that this particular instrument is not creating any right if it is not registered.
For that, you don't have to rely on section 53A or 71.
No, 53A, I'm not going. I suggesting that
up to now your entire submission is on 53A and 17(1), which operates within the limited realm of 53A. Because they are not projecting this as a shield or a defense. If that is not done, section 53A question does not arise.
And
either you could have argued that this is a direct transfer.
Yes, I stick on that.
Be so, then you have a better case. But 53 is not at all.
When it's
their suit, they assert as a sword, not as a shield.
And kindly speaks, that's why their suit. The suit is entirely based on the right emanates from that. And if he is suggesting that by virtue of that joint venture development agreement, he has a right over my property to develop.
You can plead under 17(1)(b) directly. If you come under Registration Act 17(1)(b), other non-testamentary instrument which purport or operate to create, declare such and such, whether in present or in future, any right, title, or interest.
Whether vested or continued, yes.
So you come under that 17(1)(b), you can argue. Let us see the development agreement whether it is present right state.
Kindly takes up page 69, it starts. I will take your lordship to the schedule itself, which will clarify. Page 82. Internal page 14 of the agreement. I'll get that the entire property restriction is being mentioned in Schedule A.
What is the right description of owner?
Yes, description of owner's allocation is all that piece and parcel of entire ground floor and one self-contained.
Developer's allocation is at C.
Yes, developer's allocation is the rest area.
Where is the relevant clause in the contract regarding developer's allocation?
Yes.
Let us you show us the present transfer.
So kindly takes up paragraph clause 11 and clause 12 at page 78. Clause 11 with regard to the development work and clause 12 that the developer's second party will, with the execution of this agreement, shall be entitled to book the flats of the share of as per Schedule C of the proposed building, except the owner's first party's allocated area, and shall be able to accept the booking money from the intending tenants to the said proposed building, but the owner's first party will not be liable or responsible for all the money transaction with the developers and others. Now that the owner's first party hereby agree and covenant that the developer's second party not to create any interference or hindrance or disturbance in any manner whatsoever during the construction of the said new building. The owner's first party undertake to cooperate with the developer in all respect during construction after completion of the building at the said premises, and the owner first party has no objection to issue the rent bills in favor of the intending tenants at the time of delivery or possession of the building, provided the owners shall not issue rent bill or execute tenancy agreement in favor of the intending tenants till the developers has completed the building such and such. Now,
You have clause 3, page 75. Clause 3, the second sentence says the developer second party would be able to realize the said construction cost, charges and expenses with profit thereon from the intending tenants who will be accommodated in the said building out of the developer's allocation. So therefore, developer has exclusive right to let out their allocation. So that's a present right. Next, you have this clause 12, as you read out, that developer shall be entitled to book the flats for Schedule C and shall be able to accept booking money from the intending tenants. And owners will not be liable, but they will not be responsible. So therefore, that is also in favor of your argument. That was exclusively given. 15 says owners first parties shall never demand any money from the developer except their allocation. They'll be excluding your allocation. The developer's allocation.
so far as regards the developer's allocation is concerned, the right is not the instrument is creating itself a right.
These are the clause 3, 12, and
The developer can independently deal with, I cannot touch. So if this is a clause, it's a instrument creating a transfer which mandatorily requires registration. And if it is not, in 2020 an authorized agreement, 4 months gone, this instrument becomes inoperative in the eye of law. Ipso facto, because today this cannot be even a curable defect.
but if you say clause where B is in the nature of specific performance, Mr. Mukherjee, then the relaxation regarding specific performance should come. It need not be registered.
I say, no, today, with regard to the what he has stated, by virtue of that instrument, he is suggesting that he has an independent right to develop my ground. So if we take the instrument in hand, the instrument itself suggesting two things, that yes, you can develop over my property. This will be your developer's allocation. This will be the owner's allocation. Once this instrument itself suggesting that yes, it's a transfer of interest, and if it is not registered, so today in my respective submission, no right can be not asked for before a court of law showing this instrument to be in it, because today whatsoever, not subject to correction by my law, whatsoever right he wants to agitate before a civil court is emanates from this instrument. We have to look into the other larger aspect of the issue. Kindly consider today, after 2001 in West Bengal, every development agreement requires registration, for which registration fee is 1%, and entire consideration amount which is the exchange between the parties, 1% of that. So 2% entire registration cost, as well as the transaction amount 1%, the government will lose the entire revenue. Today, if the law is being laid down that yes, in a hand, a notarized development agreement by virtue of which the parties can assert their right before a court of law, then nobody will even care to
The order will be challenging. Let us see the
yes,
appeal order.
can it take some now the memorandum of appeal order dated 13th of May 2025.
You have filed a 39-4 also, that is pending. Your main primary ground is registration, non-registration. Let us hear him. We will decide the appeal later.
Lordship, this issue minor possibly has come up for the first time in this proceeding today.
No, at interim stage, they didn't have any right of hearing.
No, because in the written objection, as of in the memorandum, this ground has never been taken. They have taken the registration agreement. They have never executed any development agreement. It is a forged document.
But even then, it was the duty of the court to look into this. They can take this.
They cannot maintain both the arguments today.
Why not?
Because once they say the registration agreement is there for in.
These are two different arguments. One is they dispute the agreement totally.
Right.
Now, even if they dispute the agreement, the learned trial judge, it was the duty of the learned trial judge to look into whether it is a registered document. Because the language of Registration Act is that it cannot be looked into. If it's unregistered and it's compulsory registerable, then that agreement cannot be relied on before any court of law. That is 49.
Yes.
49, the language is mandatory. I mean, effect of non-registration, no document required by section 17 shall affect any immovable property, confer any power, be received as evidence unless it has been registered. If that be so, you cannot claim a right on the basis of that.
So far as that issue, Lordship, kindly allow me a day's time, I shall come prepared on the issue, because the entire appeal proceeds on the basis that it is they have never executed the document. There is no development.
It is a different argument altogether. The present, we'll come back, we'll put it in the list more. The present appeal has been preferred against the ad interim grant of injunction in a suit filed by the plaintiff stroke respondent inter alia for a decree for declaration that a development agreement dated January 9, 2020 executed between the parties is subsisting, and that the plaintiff stroke respondent has a right to develop the property on the basis of the same. Next para, learned counsel for the appellant argues that the ad interim order of injunction was granted on the basis of the development agreement, which is merely notarized and unregistered. Next para, learned counsel places reliance on section 17 within bracket 1 capital A bracket closed of the Registration Act 1908, read in conjunction with section 53 capital A of the Transfer of Property Act 1882, to argue that by simultaneous introduction of section 17 within bracket 1 capital A in the Registration Act and deletion of the mandate of registration in section 53 capital A of the Transfer of Property Act, comma, the intention of the legislature was to retain the bar in respect of an agreement in respect of a written agreement contemplated under section 53 capital A, insofar as no reliance could be placed on the same unless it is registered. Next parallel, counsel cites the judgment of Commissioner of Income Tax versus Balbir Singh Maini, MAINI, reported at 2018-12 SCC 354 in such context, and argues that the Honorable Supreme Court held inter alia that there is no contract in the eye of law in force under section 53 capital A after 2001 unless the said contract is registered. Full-stop. Next part. After 2001, this is a 2018 judgment.
Yes, 2001 was the amendment.
2012. Full-stop. Next para. Learned counsel further submits that in view of the relevant clauses of the development agreement, comma, the said agreement created rights in presentee in favor of the plaintiff stroke respondent, comma, the developer, and as such the document was, comma, in any event, comma, compulsorily registerable under section 17 within bracket 1 within bracket small b of the Registration Act as well. Full-stop. Next para. As such, comma, it is argued that the ad interim order of injunction on the strength of such unregistered document was palpably bad in law. So next para, this appeal is required to be heard on the above question and as such is admitted. So since the learned counsel for the respondents is also present, comma, we invite the parties to argue on the merits of the appeal, comma, since the short question of law involved at the stage of passing of ad interim orders would be the only question to be resolved in the appeal itself. Full-stop. Learned counsel for the plaintiff respondent seeks a day apostrophe adjournment to come prepared on the appeal, and in addition, comma, submits that the argument now sought to be made before this court is alien to that made in the court below, in the trial court, comma, both in the application under Order 39 Rule 4 of the Code of Civil Procedure and the written objection to the injunction application filed by the appellants. Full-stop. Furthermore, comma, it is contended that the said ground is not mentioned in the memorandum of the present appeal as well. Full-stop. Next para. However, comma, this court is of the opinion that the question of non-registration of the document, comma, which is the very premise of the claim of the respondent in the suit, on the premise of alleged violation of section 17 of the Registration Act, is a pure question of law and can be raised by the appellant at any point of time. Full-stop. Next para. However, comma, we cannot accept the argument of the appellant insofar as the applicability of section 17 within bracket 1 capital A of the Registration Act is concerned, comma, since the said provision, comma, read in conjunction with the amended section 53 capital A of the Transfer of Property Act, comma, as construed in the light of Balbir Singh Maini apostrophe case supra, is restricted to the operation of section 53 capital A of the Transfer of Property Act alone and cannot apply to an assertion of title on the strength of the document by way of a suit. Full-stop. Next para. as held by the Supreme Court in Balbir Singh Maini Supra as well, Section 53 capital A affords a shield, by way of a defense to any action taken on the strength of title or interest in respect of a property and cannot operate in respect of a plaint, when the agreement in question is sought to be relied on as a shield, as a sword, and not as a shield. Full stop. Next para. Section 53 capital A of the Transfer Property Act specifically provides that where any person contracts to transfer for consideration any immovable property by writing, then notwithstanding where there is an instrument of transfer, that the transfer has not been completed in the manner prescribed therefore by the law for the time being in force, the transferor or any person claiming under him shall be debarred from double inverted মধ্যে enforcing against the transferee and persons claiming under him, double inverted clause, any right in respect of the property of which the transferee has taken or continued in possession. Full stop. Next para. Thus, it is iterated. Thus, the above logic is strengthened all the more by the very language used in section 53 capital A, who said in the present case, the agreement in question has been sought to be relied on by the plaintiff stroke respondent as a shield and not as a as a sword and not as a shield or defense. Hence, neither section 17 within bracket 1 capital A of the Registration Act nor section 53 capital A of the Transfer Property Act is applicable. However, from certain clauses of the development agreement, such as clauses 3, 12 and 15, which is annexed to the connected stay application, we find that an arguable case has been made out as to transfer in presenti of title with regard to the developer's allocation of the subject property, which might bring the agreement in question within the fold of section 17 within bracket 1 within bracket small b of the Registration Act. Full stop. Next para. In the event it is ultimately held that the agreement is indeed governed by the said provision, consequentially section 23 of the Registration Act, as argued by the appellants, is also attracted, thereby putting a terminus to the entitlement of the appellant's respondent on the strength of the unregistered agreement, since the time for registration is already over. Also, in such case, the effect of non-registration as enumerated in section 49 of the Registration Act is required to be considered, more so since the suit is not couched in the form of a suit for specific performance, in which event the proviso to section 49 might have provided the respondent with a breather. Full stop. Next para. Hence, the appeal is required to be heard on the question as to whether the aforesaid clauses of the development agreement debar the plaintiff stroke respondent from claiming any right or obtaining any injunction order on the strength of the said agreement, which is unregistered. Full stop. Next para. On the pair of the respondent number 1, on the pair of the respondent, the appeal be posted for hearing under the same heading along with the connected application tomorrow. Tomorrow.
After tomorrow.
Let it be the
Because I have
you burn midnight oil. Yes. Proverbially.
I shall cite that chapter of application which helps because that the
Give,
development agreement.
just give the citation to your learned
Yes,
friend
I
to read.
Yes, sure.
Yes.
Item number 56.
What is the defect?
Sequel and alphabet.
What is the defect?
The certified copy applied on my there is in my opinion there is no delay.
No delay. Why? Let us see.
Certified copy applied on 23rd May 2025.
Just check. This is a challenge against what? Injunction order?
Misappeal. This is my misappeal. Misappeal was initially dismissed for default.
Misappeal against what?
Misappeal against my lord. There is there is an application. I can't see the order.
What was the miscase under?
Miscase under my lord. Section.
Order 9 rule 30. You are the defendant in the suit.
I'm the defendant in the suit. There is two applications were filed.
No, order 9 rule 13.
Order 9 rule 13.
No, for the second appeal is applicable.
My lord, this is not order 9.
Must be.
There are two applications were filed under order 11 rule 50 and another application was filed under for registration section 72. My lord, by these applications, my lord.
What section 72?
72 of the Westminster premises commission. And I see the order dated to 17 May 2007.
Both are divisible.
Page 19. No, my lord, there is a appealable order. There should be this case, my lord. 17 May 2007 order 95. Page 27, my lord, this is my application order 9 rule 9 and our order 1 rule 10 subset sub rule.
Order 1 rule, order 9 rule 9.
Order 9 rule 9. Page 27, my lord.
You are the plaintiff.
I'm the plaintiff. Order 9 rule 9. That is why my lord.
And order
Page 27, my lord. Kindly see. Order 9 rule 9 along with order 1 10 2 page 62.
Please come to order 43. Do you have the code of civil procedure? Take order 43. Take order 43 rule 1 C.
It's an order under rule 9 of rejecting an application appeal from order. So exactly.
An order, yes. Your application has been rejected.
That is.
So you're challenging that component.
Yes, the misappeal was dismissed for default. I filed the restoration application within that.
Yes.
And that day when the misappeal was dismissed for default, that day there was a ceaseword in the court. And my lord, moreover, the appellant, he died prior to that passing of the order.
So is the name of a dead person.
Dead person.
Tonality also.
Well, kindly see the death certificate I have annexed.
No, you took this point before the trial court.
Yes, yes.
Why was it? How was it dealt with?
In the kindly see the.
Let us see the first limitation first. Limitation, the order was passed on 21st of May 2025.
Yes. Certified copy applied on 23rd May 2025 and it was handed over on 12th December 2020. And the appeal was filed on 19th December.
Yes, within time. It is rightly pointed out by learned counsel for the appellant that the report of the stamp report, additional stamp reporter to the effect that the appeal is time barred is erroneous, inasmuch as the time taken for obtaining the certified copy was not deducted by the additional stamp reporter while so reporting. Full stop. We find that the appeal is within time. Full stop. Next para. The present challenge has been preferred against an order whereby an application for restoration of a suit under Order 9 Rule 9 of the Code of Civil Procedure was dismissed. Full stop. Next para, learned counsel for the plaintiff stroke appellant points out that the suit was dismissed on a day when one of the parties had already died and as such was passed in the name of a dead person. Full stop. That apart, comma, there was seizure to say. That's not a valid ground.
That is also mentioned in the
Apart from that, comma, the petitioner, comma, being a layman, comma, was handicapped since on the relevant date when the suit was dismissed for default, comma, the petitioner did not have any access to legal assistance in view of a siege work going on in the concerned court. So, next para, we find a sufficient prima facie case for hearing the appeal on merits having been made out. So, accordingly, FMAT 513 of 2025 is admitted to be heard on the above questions as well as the other grounds taken in the memorandum of appeal. What is this appropriate order is for early hearing?
Right. Yeah.
Very well. The plaintiff can 1 of 2025 is taken up for hearing. Full stop. It is an application for appropriate order for expeditious hearing of the appeal. Full stop. In view of the innocuous nature of the prayer, comma, prior service of notice of the application of the respondent is deemed irrelevant. Full stop. Next para. The appellant accordingly can 1 of 2025 is allowed, thereby directing the trial court records should be called for the trial court record or the dismissal. If you annex all the relevant documents,
I have annexed all the Miss appeal, order, miss case order.
Their objections?
Their objection also. Written objection to the resolution application.
You annex the plaint.
I have annexed the plaint.
Plaint, the order of dismissal for default. Your order and rule line, they are written objection. Very well. Last sentence can disposed of by observing by dispose of by dispensing with calling for the trial court records in view of the relevant documents being annexed to the present application. Next para, the appellant shall put in postal costs and due requisites for service of notice of the appeal on the only the plaintiff. On the plaintiff stroke respondent number 1 within a week from date. Next para, service of notice of the appeal on the respondent numbers 2 and 3, comma, who are respectively pro forma defendant number 2 and defendant number 1 in the trial court is dispensed with in view of no relief having been sought in the appeal against the said respondents. Next para, the appellant shall prepare and file the requisite number of informal paper notes by incorporating the relevant documents within 4 weeks from the date of service of notice of arrival of the trial. Within 4 weeks from date, and serve an advance copy of the same on the respondent number 1 and or the learned advocate for the respondent number 1 if appearance is entered in the meantime for the said respondent. First of liberty to mention the appeal for inclusion in the list for hearing as and when the same is ready for hearing. You only have to put in the special postal cost and requisite. When they are served, then you can mention the appeal. And you prepare informal paperwork within 4 weeks from date with these documents. Next.
Item number 57 and 58.
We are late by in this matter we are from the appellant.
Order yes.
I am for the appellant late by Mr. Prantik other was hospitalized.
When hospitalized?
Today morning.
On the last occasion also,
No, I have not been asked.
Somebody else asked for it. No.
Yeah.
On the prayer of the appellant, let the matter stand adjourned till next week, till January 19, 2026.
Item number 59.
My lord, item number 59, my lord. May I be permitted to join virtually? I appear for the appellants, my lord.
Yes.
My lord, this is an appeal whereby my lord challenging an order.
No caveat.
No caveat, my lord. My lord, sir, sent down these records, my lord. My lord, what had happened, my lord, in a suit for partition, where admittedly all the parties are possessing portions of land upon mutual agreement with the or improved order records. Well, the appellants have been restrained with an order of status quo. What they are doing, they are constructing or upgrading rather their kacha structure into a pakka structure. Now the plaintiffs admittedly reside in the property. They have upgraded their house. Now I have been restrained. My only prayer is to the limited extent that I may be allowed to carry out the construction because I have a sanctioned plant.
You'll have to
And
serve
it has, my lord, I shall serve.
the present appeal has been preferred against an ad interim. No,
No, final disposal.
Yes, against an order whereby the temporary injunction application of the plaintiff stroke respondent was allowed, thereby directing the plaintiffs as well as the defendant numbers 1 and 2 to maintain status quo in the suit property regarding its nature, character, and existing position as on that date till disposal of the suit. To the next parallel, counsel for the appellant submits, learned counsel for the defendant stroke appellant submits that the parties have admittedly been residing in their respective allocated portions of the property since long, whose of that apart, comma, it will be borne out by the records that the plaintiff stroke respondent. How many plaintiffs?
Well, there are more than other 5.
More than one. The plaintiff stroke respondents, comma, being the other co-owners, comma, have already made pakka constructions in their respective occupied portions of the suit property and are enjoying the same. So, it is argued that the suit was filed and the injunction obtained at the juncture when the defendants stroke appellants were raising pakka construction by demolishing their previously occupied kacha structures on their portion of the suit property. So it is thus submitted that the balance of convenience and inconvenience and equities lay in favor of refusal of injunction. So we find a sufficiently arguable case having been made out. So accordingly, FMA 1568 of 2025 is admitted to be heard on the above ground as well as the other grounds taken in the memorandum of appeal. So, sir, appropriate order means early hearing.
Well, Lord, there was a relaxation for continuing with the limited modification to continue with the construction as per sanction without equity.
That will be allowed here.
Well, I'll serve the application.
Very well. In view of the limited scope of the appeal, comma, the appeal is required to be heard along with the application. For such purpose, calling for the trial court records is dispensed with for the present. For subject, the appellant shall serve copies of the application as well as the memorandum of appeal on the plaintiff's respondent numbers 1 to 5, indicating that the appeal and the application will be listed for hearing under the same heading in the monthly list of February 2026. Service of notice on the defendants respondents 6 to 9 is dispensed with, comma, says no relief shall be sought against the said respondents in the appeal. Preparation of formal paper books is dispensed with for the present. Managed all documents or some other documents are there?
No, my lord, all of their plaint, injunction, my objection, all are on board. All are attached to the application.
After line add to the
Grateful.
Liberty is given to the parties, comma, if so required, comma, to produce further or documents for the parties in the trial court at the time of final hearing of the appeal.
Grateful, deeply.
Application, same heading. Same heading. Order 41. Under the heading application, under the same heading, under the heading application. Appear under the heading application, but hearing of the appellant date. There was server copy of this order along with the copies.
My lord, I shall.
Yes, next.
Item number 60.
And for the plaintiff, appellant individual, my lord.
Right.
Suit for my lord, partition and permanent.
You have carried out the necessary amendment and whatever.
Suit for partition and my lord permanent injunction, my lord. In that suit, my lord, the plaintiff took out an application for injunction under 39 rule 1 and 2, that is section 151, my lord. In that, my lord, application, initially, my lord, the order of adjudication, order of injunction was granted, my lord, in the nature of status. And my lord, the prayer in my injunction application was that, my lord, and the page 20, my lord. My lord, page 20.
Yes.
Relevant page, my lord. Prayer portion, my lord, page 22, my lord. Not to, my lord, not to create any, my lord, disturbance in my peaceful position, and my lord, not to, my lord, make any construction,
Change in nature character.
change nature and character
Yes.
in the disposal of the suit, my lord.
Yes.
And my lord, thereafter, my lord,
Why refused?
my lord, not review, my lord, injunction application rejected thereafter, my lord.
Why?
And their application, my lord, for continuing the construction, that application allowed, my lord. My lord, can you see the impugned order, my lord?
That application has also been annexed here.
Yes.
Their application for continuing construction has been annexed to your application. If the order was passed on both, then it should. Yes.
Nothing of mine has been annexed. That is the difficulty. But my objection.
Objection is you have to
Objection.
annex all these documents. How do we?
Later.
Madam, can I take a short immediate matter to this application?
No, first let us admit these. Yes, what is the ground on which it was dismissed? Let us see that.
My lord, dismissed that, my lord, the suppression of fact, the landed court taken.
Let us see the impugned order. Please place the impugned order.
The both parties filed their respective hazira. Today is fixed for passing order in respect of the petition dated 8th October 2023, filed by the defendant number 1, peruse the petition and materials on record. During hearing, learned advocate for the defendant number 1 submitted that the defendant number 1 raised the construction over the suit property before filing of this case up to 18 pillar and tie-beam, and the plaintiff has suppressed this fact in this claim. Learned advocate for the defendant number 1 has further submitted that the court by its order number 7 dated 9th October 2023, 9th August 2023, directed the defendant to produce the permission from the authorized authority for making construction. Learned advocate further submitted that the defendant has already got permission and conversion in his favor, and therefore he should be allowed for completing construction. My submission, my lord, not got the, my lord, permission of, my lord, sanction plan, proper authority, my lord. On the other hand, learned advocate for the plaintiff raised strong objection and submitted that the permission is not proper and the concerned authority is not the appropriate authority for granting permission. Learned advocate referred a judgment of the Honorable High Court cited in 2023 Volume 3 ICC 213, where the Honorable High Court has been pleased to reject a petition of raising construction. Peruse the petition dated 8 August 2023 and materials on record, including order number 7 dated 9 August 2023. On hearing and perusal, it appears that on 9th August 2023, the injunction application under Order 39 Rule 1 and 2 CPC was heard by the court in part, where the learned advocate for the defendant prayed for completion of the construction. This court in the same order has observed that if the defendant is restrained from raising further construction, then the raw materials will be wasted. However, as there was no permission for making construction, this court directed the defendant to obtain the same from the concerned authority, and further injunction hearing was kept in abeyance. The plaintiff has not preferred any appeal or revision from the said order. Learned advocate for the plaintiff referred the judgment of the Honorable High Court. On perusal of this said judgment, it appears to be that the Honorable High Court has been pleased to reject the petition on non-maintainability ground only. In such circumstances, such judgment is not applicable in this instant case. The defendant has filed a copy of the order passed in MF case 1585 of 2022 including inquiry.
If this Gangasagar Bokhali Development Authority is not the authority, then which is the appropriate authority according to the Panchayat? Panchayat.
As per section
Now, here it has been stated that the sanctions were copies were given to the Panchayat also. They made no adverse report.
only the taken the plea, my lord. But the my lord, the authority granted that, my lord, the Gangasagar and Bokhali Development Authority Act 2024, my lord. But the dispute in raised before that, my lord. So, my lord,
No, because of the permission given by the court, they had made an application and court had permitted them to obtain the permission. So, during pendency of your injunction application. So they had obtained the permission and produced that before the court. Court said that Gangasagar that Bokhali Development Authority had given permission and that copies of the development permission sanctioned by GBDA was supplied to BLN, LR, Panchayat Samiti and Gram Panchayat. No adverse report from those authorities. So therefore, you say that no adverse report does not mean that sanction has been given by the appropriate authority.
no, sir, my humble submission,
Well, let them file a, we are admitting the appeal, let them file a written objection, they'll annex everything. There are, because you have not annexed, if you had annexed all the documents, you could have heard him and decided there. Anyway, the appellant has raised, the plaintiff stroke appellant has raised.
One more thing, kindly consider this. In the injunction application, the abandonment is not that I get the construction beyond my share or in the from the west portion of the property. There's no abandonment as such.
That would not be there.
my lord, I have stated, my lord.
Learned counsel for the appellant argues, Learned counsel for the appellant argues that by the impugned order, the learned trial judge erroneously dismissed the injunction application filed by the appellant, filed by the plaintiff appellant in a partition suit by taking into consideration a purported permission of construction sanctioned by the Gangasagar Bokhali Development Authority, which, as per the relevant statute, is not the appropriate authority to grant such sanction. So it is argued that although the learned trial judge referred to the development permission having been supplied to the appropriate Panchayat Samiti and Gram Panchayat without any objection from their end, mere lack of such objection does not confer sanctity on the sanction granted by an authority not empowered in law to grant the same. It is further submitted that the learned trial judge failed to take into consideration the ad interim injunction which was being enjoyed by the plaintiff stroke appellant during the relevant period. Learned counsel for the respondent controverts such allegation and submits such arguments and submits that nowhere in the injunction application has it been stated that the defendants respondents are making construction beyond their share of the suit property. Next para, such contention, of course, is controverted by learned counsel for the appellant. Be that as it may, in view of the arguable questions raised, the appeal is required to be heard. Accordingly, FMA T 359 of 2025 is admitted and shall be heard on the above grounds and the other grounds taken in the memorandum of appeal. Next para, in view of the short purview of the appeal, the appeal, in view of the short, the respondent shall file their affidavit of opposition to the injunction application bearing Can 1 of 2025 within a fortnight from date, annexing all relevant documents, which the reply, if any, shall be filed within a week thereafter, which of the application shall be listed for hearing on February 10, 2026. What?
Legal this will be responded one. My page 8, my clear.
The permission that was granted is the 1st of February 2024. And this application was heard in July 2020.
But if you make construction in the meantime, this appeal will be done. Yes, both parties shall be restrained by an order of injunction from making from changing the nature and character of the suit property till February 28, 2026, or until further order, whichever is issued.
Item number 61.
Defendant number 1 is the adjournment.
Right.
Super partition, order of injunction is different. The case of the, there's a previous partition deed was executed between the vendor of the parties. And they have transferred their property according to the share they have got from that deed of partition. So there is no jointness of the or unity of interest. Apart from that, we have got the sanction plan, started construction up to first building has been completed. And now, my lord, this at the time of construction of the second story building, they have filed this application for injunction. The two things, my lord, I want to canvass with your lordship. One is whether there is jointness of interest between the parties or not, and whether allows me to construct such a portion, my lord, whether there is no scope now, my lord, for the extending. It is now vertical. Whatever the encroachment made is
Why they allow?
no, it is by injunction allowed only on the ground at this stage. My lord, if your lordship can you consider? The my lord is looking at the impugned order, second page. Last 1, 2, 3, 4, 5, 6, 7, 8, 9. I'm intending to vote at this stage. And I will find at the bottom that the suit is still the undivided property of the plaintiffs and the defendants. Hence, I think that the plaintiffs are entitled to protect their shares in the suit property.
Boundaries have been mentioned only as agricultural land. The
Because
specific mentioning of the plot numbers.
yes, only if there is a if the parties on the basis of such transfer the property, because the lordship find on the basis of which the transfer were made by the legal heirs of the original owner. If that be so, my lord, prior to say I can satisfy lordship whether there is joint interest of interest. Apart from that, I am the owner of 59 acres of land. This is the owner of 6 acres. Be as it may, I am not on that also. I am making construction over only 20 acres, 1/3 of the my admitted share.
The present challenge has been preferred against an order whereby temporary injunction was granted, thereby disposing of the injunction application filed in a partition suit by the plaintiffs stroke respondents. Learned counsel for the appellant argues, defendant stroke appellant argues that despite the learned trial judge having taken into consideration the fact that the vendors of the respective parties to the present suit had effected a valid partition between themselves by way of a partition deed, the learned trial judge came to the conclusion that since the boundaries of those plots had been mentioned only as agricultural lands without any specific mentioning of the plot numbers or the names of owners of the adjoining lands, at this stage it cannot be held that the demarcations of the portions are proper. Next para, it is argued that such premise is erroneous in law in view of the properties being admittedly separate and having been separate from the inception, by dint of the partition deed executed between the vendors of the respective parties. So next para, secondly, it is argued that the defendant stroke appellant had already made construction of the first floor and was on the verge of constructing the second floor, and as when the injunction was granted, so as such, it is submitted, there is no scope of lateral or horizontal extension of the construction, even if permitted, and as such, the learned trial judge failed to take into consideration equitable principles in restraining the defendant stroke appellant from making further constructions at this belated stage. So next para, the appeal is required to be heard on the above questions and on the other grounds taken in the memorandum of appeal and is accordingly admitted. No scope of
Number 1 and 2, there is no scope for any order. I'll let you solve the copy.
The
Appellant find the compilation of the documents which are relied.
The appellant shall serve copies of the memorandum of appeal and can 1 of 2025 on the plaintiff stroke respondent number 1 and 2, indicating that the matter shall be listed under the heading application on February 16, 2026, full stop. Affidavit in opposition, if any, shall be filed within 3 weeks from date. To sub reply thereto, if any, shall be filed within a week thereafter. To sub next para, the service of copies and notice on defendant numbers 2 to 19 stroke pro forma respondents is dispensed with in view of no relief having been sought in the appeal against the said pro forma respondents. So the next para, the plaintiffs, the defendants stroke appellant will be at liberty to produce, to file a compilation of further documents which were before the trial court at the time of hearing of the application. To stop in such event, comma, the appellant shall serve a copy of such compilation along with the present application and the memorandum in advance on the plaintiff's respondents.
Item number 62.
No, why? On the prayer of the appellant, let them attest appellants, let them attest and adjourn for the day. Give your appeal, Mr. Yes, anyone else is appealing with you or what? Getting on?
Number 63.
Yes.
Yeah,
Yes.
explain now what is the appellate appeal arising out of an arbitration proceeding. Section 9 application.
Section 9 has been allowed or rejected?
Allowed.
Oh, you're the respondent.
The practically implementer has lost its force. If you are because for 3 months.
Yes. No reference. No reference.
As of not, we have not received it. Apart from that, my ground current will not be paying credit to ground number 1.3.
So arbitration act.
And ground number 1. Any jurisdiction matter to party. This is no commercial matter. Move that in non-commercial. That is my sole ground.
We'll see the plaint and the value. What is the valuation?
If 5 pieces arising out of partnership.
Commercial sector.
Yes.
Commercial sector.
Section 215. Yes. 2 clause C15.
15. This falls under 15. Partnership.
Partnership.
The agreement has been annexed anywhere.
But from the judgment you also will get whether if that agreement is partnership.
Just the partnership agreement.
Yes. This is arising out of partnership. Only point is very partnership.
Where is the partnership agreement?
The partnership agreement is not in annexed, right?
Not annexed. You don't have a copy, Mr. Patel.
I have to. Yes.
If they relied on that, we can look into it.
Based on this, the entire basic ground, well and
Yes.
And
what about the valuation?
Valuation.
How do we?
Section 12, Section 2C
DI specified value and it goes to another section 12.
For whom? For whom are you waiting outside? You told somebody that you were waiting outside for him. For whom? You also want to share, yes. You heard the first part of the sentence, what about the same? Yes. 12.
12, yes.
So relief sought in a C.
Immovable property or to a right therein, the market value of
What was the nature of the dispute, Mr. Bhattacharya? We have to explain that.
we not hand over the partnership.
Or then we don't have copies of that. You don't want to soil that. That is the original. And then you will have to use that. Yes, alienate the suit property information. The valuation of the property given in that agreement.
Yeah. Remember that in the agreement, partnership agreement says that each partner will provide 5 lakhs each. It's the same amount. Okay, well,
So what is the designated valuation for this? Is which code? HON'BLE. So what is the valuation there? The specified value is 3 lakh.
Specified value is 3. It should be moved because the one new town and the having.
Yes. So commercial dispute 1. Secondly,
Specified value.
the commercial dispute therefore.
Yes.
Yes. Specified value comes within commercial dispute.
Yes.
And also that this the period there is no reference to arbitration as yet within 3 months.
Well, we have made.
You have made a reference.
Yes, we have issued a letter
To them.
to them.
They appointed.
They have also replied.
They appointed an advocate, senior advocate saying, we have said that there is no such senior advocate in the insurance.
What is their reply?
No, there has been a reference.
This is their reply.
What about the commercial good argument?
But what happens is that there was a partnership. Now, there were 3 partners. Only one partner is surviving now. Both the partners are other 2 partners.
How can the partnership sustain?
Yes. Now, only one partner is there. So, 2 of the partners have died. Their legal heirs have not brought into the partnership fund. So, the partnership has dissolved. Now, only with regard to the assets of the partnership, this has to be shared between the parties.
The valuation obviously is more than 3 lakh.
But what happened, the appellant, his mother was a partner of the partnership fund. But she
This is the asset of the partnership on this immunity.
She didn't infuse any funds. She only infused she only put the property, the land, over which the cinema hall was.
No, the question is by Mr. Bhattacharya is it's a commercial dispute. It's obviously partnership deed is covered by commercial dispute if it is of specified value. If the shares of the partners are in lakhs, it obviously the immovable property in that area, I mean, it's a cinema hall, theater, I mean, cinema theater, whatever you call it. So it has to be more than 3 lakh. So why should we go with the commercial?
Each of the partners, partner 2 and 3 will not infuse 2 lakh.
It is on the dispute. But you have sought an injunction in section 9.
Yes.
In respect of the Kollani cinema situated in such and so many plots. So obviously commercial dispute. So it's without jurisdiction.
They have not raised this point at any point of time.
Do they?
In the contested
No, they are not required because
in the contested hearing before the learned court below, this was not raised.
Not raised.
It was finally disposed of. Section 9. They have not taken this point in the objection also. They have accepted. If your lordship kindly.
The jurisdiction is statutory.
Yes.
I mean, the bar is statutory.
Then kindly permit my lord, ask to my lord, prefer my lord, input response.
We'll do that. The present, in view of arguable questions of fact and law being involved, FMA 1738 of 2025 is admitted to be heard on the grounds taken in the memorandum. So, next para. It is argued by learned counsel for the appellant that the civil court which passed the impugned order under section 9 of the Arbitration and Conciliation Act 1996 did not have jurisdiction, since the dispute between the parties, as per the section 9 application, comes within the ambit of commercial dispute as envisaged in the Commercial Courts Act 2015. So, next para. It is further contended that, to the knowledge of the appellant, no steps have been taken for reference to arbitration, despite the lapse of the statutory period of 90 days as envisaged in section 9 within bracket 2 of the Arbitration and Conciliation Act 1996, thereby rendering the order impugned before this court academic. Next para, learned counsel for the respondent, petitioner stroke respondent number 1, the main contesting party, disputes both such contentions and hands over a photocopy of a letter dated December 15, 2025, whereby, purportedly, a reference was made to an arbitration. Reference was made to arbitration. Thus, it is submitted that the matter does not come within the domain of section 9 within bracket 2 of the 1996 Act. Insofar as the objection as to the dispute being commercial, it is submitted that at no point of time did the present appellant raise such objection before the section 9 code. Thus, it is contended that the appellant is precluded from taking such point for the first time before this court. So, next para. Please hand over a copy of the partnership agreement. At least a copy during the course of the day. Please hand over. We'll keep it on record. Hand over. We'll keep it on record. A copy of the partnership agreement, on the basis of which the application under section 9 of the 1996 Act has been preferred, is handed over to this court. Next para. From a perusal thereof, it transpires that, looking into the respective shares of the parties to the partnership agreement, which was the subject matter of the dispute, it is evident that the assessment of valuation of the dispute would be much above rupees 3 lakh, which is the specified value within the contemplation of section 2 within bracket C1 within bracket small I of the Commercial Courts Act 2015. Next para, that apart, since the premise of the dispute is a partnership agreement as contemplated in section 2 within bracket 1 within bracket small c within bracket Roman XV bracket closed of the 2015 Act, there cannot be any manner of doubt that the dispute pertains to a commercial dispute as contemplated in the 2015 Act. Furthermore, from the schedule of property, in respect of which relief has been sought in the section 9 application, it is evident that the same pertains to a cinema hall which is spread over at least 6 RS plots. Thus, by no stretch of imagination can it be said that the specified value of the dispute would be less than rupees 3 lakh. Thus, even without going into the question as to whether a reference has been made or not, this court finds that the learned trial judge did not have the jurisdiction to pass and to entertain the dispute, being a court of ordinary civil jurisdiction and not a designated commercial court within the contemplation of the 2015 Act. Next para, as such, insofar as the objection of the plaintiff, objection of the petitioner stroke respondent number 1 to the effect that the issue as to the matter being a commercial dispute was not raised in the section 9 court, we are of the clear view that the bar of law inbuilt in the Commercial Courts Act 2015 is an inherent subject matter bar, and as such, hits at the root of the matter, which cannot be waived by the parties. So it is well settled that jurisdiction cannot be conferred by consent. Since the bar is in the nature of a statutory one, the same cannot be waived, and as such, non-argument on the same before the Section 9 court is irrelevant altogether to construe as to whether the bar is applicable. In view of the above discussions, there is no use in keeping the appeal pending further. Accordingly, FMA 1738 of 2025 along with Can 1 of 2025 are disposed of by setting aside the impugned order bearing order number 17 dated August 27, 2025 passed by the learned district judge at HON'BLE in miscellaneous case number 31 of 2025 and holding that the application under section 9, that is miscellaneous case number 31 of 2025, is not maintainable before the said court. Next para. Accordingly, the application under section 9 itself be deemed to stand dismissed on the ground of lack of jurisdiction. However, it is made abundantly clear that nothing in this order shall preclude the petitioner stroke respondent number 1 from presenting an application under section 9 of the Arbitration and Conciliation Act 1996 afresh on the self-same cause of action before the appropriate commercial court having jurisdiction. For such purpose, liberty is granted to the learned advocate on record for the for such purpose, secretary. Next para. If such an application is preferred, it will be open to the said court to decide all issues independently and in accordance with law. Next para, we further clarify that for the purpose of section 42 of the Arbitration and Conciliation Act 1996, the commercial court where the application under section 9 shall be presented may be constituted at the first court where an application in connection with the agreement is filed, in view of the court of the learned district judge at HON'BLE not being a court competent within the contemplation of the 1996 order.
Item number 64.
Yes.
The last occasion that you allow the convention application Can 1 of 2025 and also that we documents that file certificate and judgment judgment details transfer have already incorporated the judgment details.
That is sure. Yeah. Yes, it is there. So what is the appeal about?
They will stay up. 18 months, the application.
The application taken 5 years. That was allowed. We had admitted the appeal. Second appeal. Has to be admitted first.
Yes. Yeah.
What's the application?
Can 225.
First, you have to admit the appeal. If you dismiss the appeal and not offer to, there is no motion of it.
My lord, the big fact of the applicant plaintiff instituted a suit against the defendant for declaration and injunction, and the declaration and injunction, the respondent defendant has
You are for all the respondents.
here. The defendant as the subsequent defendant has represented by filing their written statement, and subsequently the suit was dismissed on partition.
So for declaration of title.
Declaration of title, cancellation deed.
Cancellation of a what deed?
3 deeds, right?
She deeds, what deeds? She give deed, transfer, sale deed.
Sale deed and development. And I have already annexed.
You had executed the deeds.
Yes.
You denied execution altogether, or said that it was misrepresentation. You were made to understand that you were executing something else.
No, I have already executed the deed.
You admit the execution of the deed.
I have already filed 3 deeds for I'm paying for cancellation of deeds. Right?
Cancellation of deeds purportedly signed by you, executed by you. Otherwise, how could you challenge the seek cancellation?
They have their allegation, my lord.
Their allegation is that you had executed.
Yes.
What is your plain case? That you did not execute at all. It's not your signature. Or that you are made to understand it's some other deed. Come prepared, please. Cannot do one matter like this.
I have trouble to tell the internal page 8, my lord.
Of what?
Certified copy, my lord.
Of which code?
Calcutta, my lord, order dated 10 December 2015, my lord. Issue number 5, 7, and 8, my lord.
What is your case? Please come prepared in the matter. You have to apprise us as to what is your case.
That is, well, I'm defect.
You can't even answer whether the deed was executed by you or not according to them. Secondly, you can't answer on what ground you have challenged. There may be several grounds of challenge. I may challenge a deed on the ground that this deed is manufactured. I never executed it at all. Secondly, I can say that I was made to execute certain documents which were later converted to these transfer deeds. I was made to understand that it was a lease deed or something else or power of attorney, that which is a usual case. What was your case?
I haven't won catalog.
We gave you that offer at the outset. On the prayer of the appellant, let the matter stand adjourned till January 19, 2026. Come prepared, please. Your entire plain case should be at the tip of your fingers.
Item number 65.
Please continue for the rest.
I said when that he's compared so that you can take it up the next day. I want to make place, but
You are for the
as back for the petition, right? But would it be your lordship's pleasure, my lord, to give it some prior lordship doesn't fix times ordinarily, but I am told that he is not keeping well and
what will be a convenient time for mission?
in any one time which my lord would fix, lord, so that he can be brought down.
Our motion normally especially fixed
Any day, my lord.
Give us a date, whichever date suits Mr. Mukherjee's diary has to be. We are giving this privilege because of Mr. Mukherjee.
Yes, that's it. Otherwise, I would have.
It would be a privilege for any court to hear.
Yes.
And we also know that he is not keeping well for quite some time. Obviously.
19 to 22, that week, my lord can keep. If my lord wants 27 to 29, also my lord can keep. Whichever day.
Sooner the better notice. তাহলে স্পেশালি ফিক্স করে ইয়ে করে দিচ্ছি মঙ্গলবারই করি জানুয়ারি 20 স্পেশালিটি তার উপরে দিয়ে দিন স্পেশালিটি ভেরিয়েবল এটা কি সকালেই তো আমাদের তাহলে 10:30 করে দিয়ে এটাকে মানে this will appear as a special fixed matter আচ্ছা একটা লাইন একটা অর্ডার নিন an adjournment is sought on the ground of learned senior counsel appearing for the writ petitioner. Full stop. Next para on the prayer of the petitioner, comma, keeping in view the stature at the bar of the learned senior leading learned counsel for the appellant, comma, the matter is shall be listed on January 20, 2026 under the heading specially fixed matter before the other regular matters on the same day. After to be mentioned and extension, we'll take up this.
Item number 10, please.
Yes, yes.
The last operation was in emergency was all orders and the not see at the time of filing, but in the third volume of minor copy, one of the original order is there. But I am and you know the all copies were
Volumes. Yes.
yes, one of
Three volumes.
filing one of the third volume one of
Three volumes. You don't have
third
volumes?
volume one of the original copy is there on the last one. Minor.
You don't have volumes?
No, that
Keep
was-
up. What copies have you given to him?
The speech has been all.
Oh, your copies have been stitched together for us. Special provision.
I think total 318 pages.
Yes, one of
We
the.
heard- Yes.
Yes. Yes, sir. But this is one of
Next week is the disposal.
we have one of the date six or fourth of this.
What is the nature of that application pending before the tribunal?
Well, this is the Chicago controller order has been challenged. My husband was a Chicago controller by the.
Your husband was the ticket controller. Husband was a ticket tenant, not a ticket controller.
No, the Chicago controller passed the issued order.
Ticket controller's wife should leave a board legislation. So you want an early hearing of this?
Hearing of this original application.
Where number is 3058 of 2023 only is supposed. They are also hard pressed. Question be direct.
The affidavit complete one of the petitioner is one of the agent.
What is the age of petitioner? 35. Age is a perception, we suppose. 70. But there are other people also, aged people languishing in the tribunal. And 23 matter, if you jump the queue like this, in other matters will suffer. What will be a reasonable time? You are appealing for the state. Jai, you are appealing for whom?
For the central.
For the central bank. What should be a reasonable time? You are the state.
2 months from then.
More than that. The tribunal is already giving dates 6 months, 8 months. Okay, we will make it 3 months from the date of communication. That will be quite. The present writ petition has been preferred seeking expeditious disposal of OA number 3058 of 2023 within bracket LRTT, comma pending before the fourth bench of the West Bengal Land Reforms and Tenancy Tribunal at the behest of the present petitioner. So, sub next para, learned counsel for the petitioner submits that the petitioner is a septuagenarian lady and seeks the intervention of the court for early disposal of the original application, comma, which is already pending since the year 2023, and affidavits have already been exchanged in connection with the same. So, sub next para, upon hearing learned counsel for the parties, comma, CO LRT 5 of 2025 is disposed of by requesting the fourth bench of the West Bengal Land Reforms and Tenancy Tribunal to dispose of OA 3058 of 2023 bracket LRTT pending before the said bench as expeditiously as possible, preferably within 3 months from the date of communication of this order to the tribunal. Full stop. For the purpose of compliance, all parties as well as the tribunal concerned shall act on the server copy of this order without insisting upon prior production of a certified copy. No obliged to cause, affidavit signed, practically taken.
Section number 67.
In our court, Mr. Khalid, on 330 days, there is more crowd than normal days.
Yes, sir.
Because the other courts, right? So all of
Everybody take the chance.
because the other courts are also sometimes they rise or they are more lenient.
Concentrates on this. But coming up against this is of a section 5 application by the land reform tenancy. Now, the consideration of delay that was sought for was for 12 years and all. So obviously, it has seen the fate of what it deserves. But the basic facts are that perhaps no condonation of delay was at all required. I'll just demonstrate that. You have the list of things. But I just want to prepare a one-page list of dates, which perhaps. But briefly stated, the petitioner, if your lordship kindly comes to the first day, 12th of May 2010, the petitioner purchased the suit property itself, property lot 44 by 5, Matheshwar Road. This is, I think, somewhere near Tangra, Kolkata 46. This is the property. Then mutation was granted. Then 26th of July 2011, June 2011, sorry, Tika controller declares the respondent as Tika tenants.
Index should be declared.
No, it is declared. The index should be declared. Like actually, when we purchased the property, we got the property free from all income tax. The conveyance says so. There was an application made to the Tika controller, and Tika controller declared the Tika tenants. Then, we came to know that our name is being removed from the record of the Kolkata Municipal Corporation because mutation was granted on 5th August 2010. Based on that, we sent a letter to the Kolkata Municipal Corporation saying that please do not remove our name.
Yes.
Then
that was on the premise of the declaration.
Then we filed the original application 3337 of 2012.
Right.
Now, if your lordship looks at the prayers, which is at page 138, kindly take the volume 1. There are private respondents in this matter.
Oh.
I'm told that everybody has been saying
we require the affidavit service. Just check up any of them.
Since it is after 3:30, that's the they are.
I said.
They might be
right.
Yes. They have been so, but
Mr. Kaur, we'll keep it on record. We'll adjourn it for the day because 3:30 that
they were there before tribunal. But I tell you, lordship, what happened. These proceedings continued before the tribunal from 2012. Now, under order of the tribunal, the records of the Tika controller was called for. Because we were not given any notice of the proceedings before the Tika controller. It was done ex parte. So, under order.
You had challenged your removal of your name from the
municipal records also, and I also challenged the action of the Tika controller.
No, in the OA.
In the OA. Both, because one was consequential to
Yes,
the other.
obviously, obviously.
So, my lord, both the players were there. And my lord, the proceedings continued from 2012. Under order of the tribunal, my lord, records of the Thika controller was produced. And only then, Lord, I took inspection of the records. After this inspection, the tribunal gave me liberty to file a supplementary application. Instead of filing a supplementary affidavit, Lord, this second petition was filed.
But in the original way, you had already challenged the Tika controller.
Yes, everything was there. Only thing goes.
How can you say you did not know of the Tika controller?
No, we had full knowledge and it was fully under challenge. Only thing, Lord, we did not have the certified copy of these documents.
So you filed a fresh challenge against the...
challenging those. It was not necessary because Lord,
that liberty was given to file a supplementary affidavit.
Yes, that liberty was given by the tribunal to file a supplementary affidavit.
So this could be treated to be a supplementary affidavit.
Yes, and this is precisely what I am saying. And the main matter can be heard not on the basis of this supplementary affidavit, this document, which are brought on record. These are not already in the records of the land tribunal.
It's a 10-minute matter.
It's just
5 minutes for recollecting what you said today.
Yes.
And 5 minutes for there.
Only I'll show three orders of the tribunal where not the record was likely to be produced, record was taken on record, and what inspection was granted. We were given liberty to take certified copies, and then liberty is given to file a supplementary affidavit. Instead of supplementary affidavit, the land advocate filed a fresh petition.
Affidavit of service is filed today and kept on record. Learned senior counsel appearing for the petitioner submits that the conspectus of the matter is short. So next para, the challenge has been preferred against the dismissal of an application for condonation of delay, purportedly for about 12 years, in preferring the concerned original application against an order passed by the Thika controller declaring the property to be a Thika property and the Thika property. Next para. Learned senior counsel submits that initially the declaration of Thika tenancy was made by the Thika controller on June 26, 2011, and an original application bearing OA number 3337 of 2012 was filed before the learned West Bengal Land Reforms and Tenancy Tribunal.
Yes.
Next para. In the course of proceedings, the records of the Thika controller were brought before the tribunal, wherefrom, for the first time, the petitioner got access to the order passed by the Thika controller. Next para, accordingly, the tribunal granted the petitioner liberty to file a supplementary affidavit incorporating the said order as a component of the comprehensive challenge. Next para, learned senior counsel submits that the initial challenge itself covered the order of the Thika controller as well as the consequential removal of the names of the petitioner from the records of rights, from the land records. Next para, as such, a supplementary affidavit pursuant to the leave granted by the tribunal would suffice. However, due to some discrepancy in the legal advice, an independent fresh original application was filed challenging the order of the Thika controller. Next para, the said original application was held to be time barred, against which the present challenge has been preferred. Next para, learned senior counsel submits that the fresh original application might easily have been treated to be a substitute for the supplementary affidavit, liberty for which was already granted by the tribunal, since in any event the original challenge which is still pending, that challenge is also which is still pending, covers a challenge to the Thika controller's order as well. Next para, in view of the short compass of the challenge, we intend to hear out the writ petition without directing affidavits. Next para, in any event, it is deemed that none of the allegations made in the writ petition are admitted by any of the respondents. For such hearing, let the matter be listed. Normal course কবে থাকে এটা?
No, Wednesday at the top, in the second half, Lordship.
Wednesday.
Wednesday, Lordship.
Not at the top. not
AD in the second, AD in the second half. only.
This listed
21st, the next date of hearing is fixed before the trial. So, Lord,
no, listed for hearing on January 2026 push-up. What is
21st, that earlier rectification, the earlier
should we
OA.
stay for the proceedings of that?
No, if your lordship permits this to be treated as a supplementary affidavit, Lord, then there is
No, but we don't know when we will be able to take it.
then Lord, kindly,
There shall be stay of all further proceedings in OA 3337 of 2012 pending before the which bench?
Lord, bench one. Just kindly give me one.
Yeah.
Kindly keep it vacant and just.
Pending before the blank bench, comma, West Bengal Land Reforms and Tenancy Tribunal till February 20, 2026 or until further order, comma, whichever is early. Fourth. Thank you.
Obliged.